My lords. Serial number 52, my lord. I need a weak adjournment, my lord. My lord. Serial number 52, man.
This for admission. Finally. Before. Wait for appellant.
Serial number 52. I am for the appellant, man.
Sorry. The number 35. What about 34? What about 34? Yes, 35. You are for appellant. You are seeking adjournment. 2006 matter. You are the appellant. 35. They submitted that the learned counsel for the appellant is unavailable. Is this matter on Monday?
My lord, serial number 38, my lord. The compromise has been suggested
And for the
and
respondent.
it is likely to be settled. Your Rashama kindly have it in the next week. That is on Friday. By that time, we will settle the dispute.
I'm for the respondent, my lord.
Respect of the passage.
Both the learned counsel for the appellant and respondent would submit that the matter is likely to be settled. Is this matter on next Friday, na?
Yes, my lord.
Next Friday.
Much obliged.
Serial number 52, my lord. I am for the appellant.
39 to 44, any adjournment?
Serial number? Serial number? 43. Yes. Special performance. You are the plaintiff or defendant. So if you are plaintiff, then the court will presume that you are not ready and willing to perform your part of the contract. 2010 matter, you must get on with the matter. Cell number 43, the request of learned counsel for the appellant. Is this matter on? Which date? You choose the date. On that day, no adjournment. No excuse. 2010 matter.
Lord, serial number 38, which was mentioned, my lord. It's in the first list, my lord.
27.
45 to 48, any adjournments? 45 to 48.
Malad, serial number 48, Malad.
40? Yes. When will you argue the matter? No, not in the month of November. In the month of October, you choose the date. Old matters. 19. The request of learned counsel for the appellant. Is this matter on 19?
Malad, serial number 48, Malad.
Yes.
I am for the appellant, Malad. Malad, I have to some instructions, Malad, from the other side. I need weeks time, Malad. If the lordship convenient to the court, Malad, may I have it on 21st or 28th, Malad? I will argue the matter.
21st. No further adjournment.
28.
21st. No. 2010 matter.
20. Oh, publish, Malad. 21st, I will argue the matter without further.
The
Serial number
request of for the appellant. Is this matter on 21st? At the last chance.
publish, Malad.
Serial number 52, my lord.
Yes.
I am for the appellant. Weeks time may be granted. Kindly proceed on 21st. I will argue the matter.
52. The request of learned counsel for the appellant. Is this matter on 21st?
Yes, man.
The request of learned counsel for the appellant. Is this matter up? Date. on 20th. Yes.
Lord, serial number 38, which was mentioned, my lord, it's in the first list, my lord. Sorry, forgot to mention about it. It is adjourned, my lord. It's in the
Yes,
first.
first
Yes.
list.
Next Friday, my lord.
Yes.
Privilege, my lord.
Admission only up to 2016. When it was allowed? Date is not fixed. Date is not fixed. Which year? 2015. Hello, Agidya. Who appears correspondent? Hello, Agitha list. The earlier application is allowed. Then first week. 2015 allowed. First week. If it is allowed. Earlier 2007. List agida.
Yesterday I have filed the application, first matter, B110. Now I am filing the another.
So what was the application we required to file?
Paper publication to, notice to respond to appellant for 181E. This my lord, what has happened?
Paper publication to appellants. Why?
Because I have filed the LR application, the appellant, whole appellant parcel. We only represent the second wife and children of the appellant. First wife and children will have not come join with this.
So they should be read as respondents.
Therefore, I filed an application to bring the LRs of appellant.
They should be read as respondents.
I have sent in the application. They have not.
See, you have not signed wakalat on their behalf. Then how can you file application as LRs of appellants?
So
You have no wakalat.
It is by notice has been ordered by this honorable.
That is incorrect. That is incorrect. You can't compel them to be appellants. You can ask them to be respondents.
Notice is served. If they come, I can file an application.
If they don't come, what will happen? Their appeal has to be dismissed. If they don't appear after publication, what is the consequence? Their appeal is to be dismissed.
I will represent the appellant.
There is no difficulty that you are representing second wife and children. There is no difficulty. As far as first wife and children are concerned, if they are not willing to join as appellants, you have to array them as respondents. You can't compel somebody to be the appellant.
We file the necessary application to transfer.
When this is 2006 matter.
We have taken the notice thrice. They have not appeared, or they have not received the notice also.
Who has taken notice?
I have taken notice.
Against whom? Against whom?
Against the proposed appellant for A1 appellant 1A to 1M.
When that order is passed for issuance of notice to the proposed appellants. That's not correct. You made a mistake.
Even otherwise,
When will you rectify? No, that's not permissible. You can't ask somebody to be appellants unless they are willing.
I one more application to transfer them now.
Learned advocate for the appellant seeks a week's time to rectify the mistake. Do it as early as possible. Let's this matter next week. Also, Ramesh also appears in RSA. I thought you are busy with KEA. Your season is over. You have filed paper book? What is the objection?
Before 19th, first, I have to fight. The fight is not anything.
5,000 you have to pay.
I
We will waive 5,000 rupees cost. He says his client is poor. Learned advocate for appellant Sri L.K. Ramesh submits that the paper book is filed and there is delay of 5 days in filing the paper book and he requests waiver of cost of rupees 5,000. Since paper book is filed, cost is waived. Paper book is to be accepted. Paper book is accepted. Yes, urgency, yeah. All right, you argue the matter. Final hearing or interim application? You're not in final hearing? The list is met on Monday. Why notice to be dispensed?
The lower appellate court also is not appeared.
Before the trial court, he was ex parte.
Yes, the defendant is dismissed.
No, before the trial court, was he ex parte or what?
He's not expert.
He contested. He contested.
Not contested.
He contested and suit is dismissed.
No, he is not contested, not at all appeared. We are the trial court,
So-
the plaintiff has not taken the steps against the R3. Against which they, so this,
You file a memo.
I felt a memo.
Unit counsel for the appellant has filed a memo to dispense notice against respondent number 3 on the premise that respondent number 3 was the defendant number 3 before the trial court remained ex parte.
Then 7 to 2.
He remained ex parte.
Dismiss against. So dismiss
That
against.
is understood. Suit is dismissed. He remained ex parte. Memo is accepted. Notice to now you know the consequence. Even if the appeal is allowed, there won't be any order against third respondent.
So this part of
Memo dated 8/3/19. And he has filed a memo to dispense notice to respondent number 3 was the third defendant before the trial court. Notice to third respondent dismissed at the risk of appellant. Yes, commence.
next topic. Suit for partition, divergent finding. Suit is the.
This is matter for admission. Next week. Next week.
Place for me.
Why it is not
The others are my relatives who were not.
just a second. What was the nature of the suit? Redemption of mortgage against so many defendants. No. Suit against so many defendants. So there was only one defendant in the first instance. He died. LRs were bet on record. So suit was decreed.
But I did not make the other.
So you are one of the LRs.
I have not made others.
Now, why others are not contesting? The property is fallen to your share. It is fallen to your share. How others are excluded? All are class 1. Then our
Market. I would only contest this comment. So I have.
notice issue ಆಗಿದೆ ಅವರಿಗೆ.
I'm not pressing that because I don't want them to be a party. That all these parties will be party application. I am not pressing that application. Only
At your risk. Better to issue notice to them. They don't choose to contest, that's better.
People with now they are right, and over there, they are not participating for almost 10 years. Now I don't know how to be able to serve them and they come on.
See, ultimately, the appeal should not be defective. Now you say that all of them are class 1 errors. How do you say that? How do you say that only the interest devolves on you? That's your fault. Don't perpetuate the fault. You filed stay application. Issue notice on I number 1 of 18 alvado. 1 of 18 to the proposed respondents. In the meantime, there shall be, and also notice on appeal to the respondent. In the meantime, there shall be stay. Subject to, ಏನಾಗಿದೆ ಇದು suit ಅಲ್ಲಿ? Mini degree na? So you are supposed to hand over the possession of the property. What is the nature of land? Agricultural land. When this mortgage was executed,
You are not getting another, the contention is that I am not the person against that prostitute. He is not me, my father. He is another person, is not my name. And I am a different person.
interim stay till next date of hearing. List is met on 15th November. What do you mean? 15th November. 15th November. Issue emergent notice on appeal memo as well as application to impede parties.
Day before yesterday, witness I was made the invoice of Kalataka. Yeah, with next week. That this officer had followed for.
What happened? You appear for?
Case number 1, 11, 13 and 17.
What happened to notice to R1 A and B?
Yesterday I was made invoice of Kalat Madad. It can't have that. Next week, but
Notice not, sir. This matter on service of.
I will verify that.
This matter of service of notice to propose respond number 1A and B.
One more service. A1 of 22, including a please, kindly issue notice.
In the meantime, registry to issue notice on I number. Office objection is Allah.
I will complain.
Unit counsel for the appellant would submit that he would comply the office objection. Office objections are. Yes, what is the conflict between you?
It's an idea pending.
Ah.
This issue. The trial court we have won. The principal court, there is some errors. And they have applied for FTP also. The respondent, FTP got dismissed by the trial court. We are in
Say number
possession-
6. Say number 6. Ah.
No, not 6. I am for number 1,
Serial number 6.
item number 6. And subsequently, last 80 years, we are enjoying the property. Now, what has happened is the respondents, or most of them have expired. The LRs have been sent the notices recently by this honorable court. There is no response. And the trial court has examined for almost 8 years. Then subsequently, they went for principal court. I will detail on this. And the LRs, nobody is coming there, except they are sending some henchmen to trouble us. We are enjoying this property.
What was the suit?
Suit was for declaration. See, my grandfather has 5 children.
One of them have already taken partition and declaration, all his property, and there is a suit for release of the properties. Only 4 of them were there. And then he never filed a case against us. He expired. Then his son, after 70 years, he files a suit for partition in our shed, the 4 brothers.
Suit is decreed.
Suit is decreed.
Appeal is dismissed.
No, suit at trial court is got dismissed. At the principal court, it is decreed. They filed an
No,
FDP.
no, FDP is
FDP
pending.
also got dismissed.
Appeal be dismissed.
Dismissed.
Then
Then subsequently, nobody is coming. Only the henchmen are coming once in a while and troubling us.
why FDP is dismissed?
Non-prosecution.
All right.
And subsequently, we have appeared before this court for an IA to stay on the orders of Principal Judge RA 87 of
So when
2007.
the FDP is not pending, there is a need to stay.
No. There is a principal court order is against us.
This principle.
The Chippewa against the order of the trial court. The trial court order got dismissed, set aside.
Understood. Decree for partition is granted by the first appellate court.
No, the trial court dismissed the entire proceedings.
Understood. First appellate court granted decree for partition. So the FDP is not pending now.
No,
So where is the cause of action to file a stay application?
the stay
FDP is
application,
dismissed.
Your Honor,
Let the notice be served on the respond number 1A and B.
already the LRs have been served last time.
No.
There's a proof.
Wait,
No, receive argument.
against whom?
The LRs of respondents.
1A and B.
Yes, sir.
Service against 1A and B is not complete.
1 and 2 serve argument.
1A and B.
Respondent, 1 and 2, expect argument proof. Okay, last to serve argument. The NSA after is a postal account at 20. I told you they have received. This is the second time it's happened.
Wait a minute. Learned counsel for the appellant submits that the notice is served on R1A and 1B.
Yes.
Registered to put up, verify and put up Monday. Verify matter because what this says, notice is not yet served. Verify matter ಕೇಳಿದ್ದೀನಿ. So let it be verified by the registry. Monday. Your filed application, issue notice on I number 1 of 2020. Hesaru? Brilliant advocate Sri K. Bhaskar undertakes to appear on behalf of respondent. This and it is submitted that the matter is likely to be settled. The report settlement is on 21st. 21st. 2:30. At 2:30. COVID. Inventory as well as accounts, both are filed. Where do you get the inventory? Well, 2022. Madam, 10.8. Yes, all right. This court provide order dated when the probate was granted. Probate or letters of administration? Probate. 6/9/2019. Allowed the petition and allowed the petition seeking probate in respect of will dated 17/3/2016, executed by Dr. Sita Bateja. The probate was granted in favor of second petitioner, who is the executor of the will. The appellant, petitioners were required to furnish the inventory as well as the accounts relating to the properties covered under the probate. On 12/8/2022, an affidavit is filed explaining the delay in furnishing the inventory as well as the inventory stack. List of inventory is also furnished, and the affidavit is also filed explaining the delay in furnishing the accounts. Accounts are also furnished in respect of the properties covered under the probate. This court has perused the affidavit as well as the list of inventories and accounts, being satisfied with the explanation offered for delay of 73 days in furnishing the inventory and delay of how many days?
No delay in filing the accounts.
The delay is condoned. Inventory furnished by the petitioners accepted, and subsequently the court has also perused the accounts produced by the petitioners. The court is prima facie satisfied that the accounts are correct. Accordingly, the accounts are also accepted. Next. Submission is made by the learned counsel for the petitioner that original will dated 17/3/2016 is produced for this court in the probate proceeding. Request is made to return the original will in favor of petition number 2. Petition number 2. Registry to retain the certified copy of the said will and to return the original on proper identification. Also, you have got copy of paper publication.
Case number 9.
Against which respondent? Against which? Probate, all right. Pass over, my friend. Pass over. Yes. Who appears for petitioner? Pass over.
What must be verified. That's all taken for twice, allowed. Third time it should not take it. Appeal against demolition.
Only against?
A to D.
Notice is served on them.
Notice was not served for the
No.
third time.
Now, recalling application notice.
It has come for first time.
This only.
That's-
Now, will you take steps today?
I will take
Huh?
more.
Today you have to take steps. Today you have to take steps. We'll recall the order.
I will take.
Who appears for respondent? So how many days delay?
100 days.
Day number 1 of 2022. despite to condone the delay of 100 days in recalling the order dated 10/2/2021. Today order dated 10/2/2021. The appeal against second respondent, seventh respondent is dismissed. Appeal against respondent number 7A to D is dismissed. Full stop. Accepting the reasons shown in the application to condone the delay. Delay is condoned. Order dated 10/2/2021 is recalled, subject to the condition that the appellant shall take steps against the unserved respondents number 7A to 7D by itself. Then what else? I number? Appellant number 3.
Three also died and one also died. Three has no issues. One has died.
Memo is filed reporting death of appellant number 3, and it is stated that appellant number 3 has no issues. Memo is accepted. Then who else died?
Appellant number 1, my lord, IA3 of 2022.
IA3 of 2022 is filed to bring the legal representatives of deceased appellant number 1. Madam? More area. 3 of 22 to 5 of 22. All the applications are allowed, and for the reasons assigned in the respective affidavits, appellants are permitted, proposed LRs of appellant number 1 are permitted to come on record, appellant to carry out necessary amendment in the appeal memo and to furnish amended cost type.
I'm appealing on behalf of the appellant. I filed an application to recall the order dated 20.
Entire appeal was dismissed. Do you have any objection? Do you have any objection to recall? Any objection to recall the order? Yes. A number 1 of 2020 is filed to recall the order dated 26/2/2020. Then an advocate for the respondent has no objection to allow the application, subject to the condition that the appellant should commence his argument for admission next week. IA 1 of 2020 is allowed. Order dated 26/2/2020 is recalled. The appeal is restored. This is met on 20th for admission. Including. Why you want to come on record? Who appears for appellant? Who appears for the appellant? Possible.
Number 1 also died.
Sole appellant died. You have served the copy on the respondent. Respondent number 1 died. Death ಆಗಿದೆಯಾ? You have filed applications? Yes. IA 6 ಅಲ್ವಾ?
IA 4, 5.
Issue notice on IA number 4 of 19, 5 of 19 and 6 of 19 to the proposed legal representatives of this is respondent number 1. Very process. Hello, ಬರ್ಲಿ.
15 I appear for the appellant, my lord. I
Yes.
filed an application for early hearing, my lord. Final
Yes, yes.
hearing, a date may be fixed in the
Respondent.
next.
You appear for respondent? You have no objection for early hearing? Yes, IA number 1 of 2022 is filed seeking early hearing. Appeal is of the year 2012. Do not counsel for the respondent has no objection to allow the application. Application is allowed. Early hearing granted. This is be found.
On date,
Which
or date may be fixed, my lord.
You choose the date.
But next week, any date, my lord.
Choose the date.
My lord,
Date of your choice.
date of maybe 8 next Tuesday, my lord, 18th
18th. Is this matter on 18th for final hearing?
obliged.
Yes. You filed paper book now? So appeal is dismissed for not filing paper book. Yes, filed, Mr. Yes, filed paper book. See, we have 2006 appeal still pending for hearing. This is 2012. What? You're opposing or what?
In fact, I am opposing it, but I leave it with you.
How much cost you are going to? See, what is the nature of the suit? Injunction. No, who is in possession?
Government land, my lord.
Yes. Who is in possession? Who is in possession? You are in possession. So you are not put to any prejudice. No, you are not put to any prejudice because of this recall. Now, if you are deprived of possession of the property for these years because of this delay in prosecuting the matter, I thought of imposing some cost on him. Yes, yes. The appeal was dismissed. The appeal was dismissed on the ground that paper book was not filed in time. The learned advocate for the appellant has filed the paper book on 6/4/2021 and is requesting to recall the order dated 29/6/16 by filing application at I number 1 of 2022. And is also seeking condonation of delay of 1,417 days. The learned advocate for the respondent would vehemently oppose the application. However, keeping in mind that the matter requires to be adjudicated on merit, and also considering the fact that the paper book is filed, the order dated 29/6/16 is recalled. Paper book filed on 6/4/2021 is accepted, and appellant shall pay cost of rupees. Our children must be young. Federal women. Cost of rupees 3,000 to the respondent. To the respondent. See, you have filed this application after 4 years. There must be some logic. There must be some logic. It should not be a matter of routine recalling orders. 3,000.
In fact, this appeal was listed.
Not a big sum. Not a big sum for petrol bunk owner. 3,000 rupees.
Sorry, my lord, I want.
All right.
There are a difference between the family.
3,000 rupees. You want me to make 5,000? 3,000. Respondent.
Respond number 2, 20. Government is respond number 1.
Government doesn't require cost.
Name, my lord.
To the interesting party, private party.
My lord, I appear for the appellant, my lord, is my application for the early hearing. I shall comply with the paper of objection on the paper book, my lord. It appears it is not served on the respondent counsel. I shall do that, my lord. The date may kindly be fixed.
The advocate for the appellant has filed the application at I number 1 of 2022 seeking early hearing. The office has raised objection in the paper book filed by the advocate for the appellant. The appellant undertakes to remove the office objections. The appeal is of the 2013. Early hearing granted. I number 1 of 2022 is allowed. Appellant to remove the office objection and list this matter for final hearing on
First week, my lord.
in the first week of 16 only. Registry to know, show the name of the government advocate in the court. Correspond number 1. Correspond number 1.
My lord, first week, my lord.
Paper books filed. What is it? No, you have to collect the copy from the registry. That is the procedure. You have any objection for early hearing? You have any objection? Respondent has filed respondent has filed application seeking early hearing. I number 1 of 2022 is allowed as there is no objection by the appellant. This is matter for final hearing on date. Choose the date. 2nd of November. ಯಾವುದು? ಕರೀತೀರಾ? Which date this order was passed? On 9/9/2022, this court passed order for citation to be published in the Kannada Prabha daily newspaper as well as Indian Express daily newspaper. Full stop. The learned advocate for the petitioner has produced the paper publication. Both published on the same day. Paper publication dated the 30th of September. Allah. On 22/9. On 22/9/2022. Stop. What is the date fixed? Today is the? Yes. Today is the date fixed for a hearing. None has chosen to oppose the petition. The publication is accepted. Is this matter for? You want any specific date? Is this matter on 15th November? Where is the maximum court fee?
For the first time that it has come up before.
Publication about
I undertake to pay maximum court fee, hence notice may be dispensed.
What is the valuation?
Valuation is about 7 crores, madam. 7.5 crores.
I number 1 of 2022 is filed to dispense notice to the Deputy Commissioner on the premise that the petitioner is paying maximum court fee under the Karnataka Court Fees and Suit Valuation Act. For the reasons assigned in I number 1 of 2022, same is allowed. Notice to Deputy Commissioner is dispensed. The petition is filed under section 278, read with section 218 and 300 of Indian Succession Act 1925, seeking letters of administration in respect of assets of late Meghana Haridev, who died on
6/11/2021, madam.
6/11/2021. The petition is filed by her husband. Her husband.
Last one.
It is stated in the petition that there are no other class 1 heirs. This court deems it appropriate to direct publication of this petition by way of citation in which newspaper? In Hindu English daily newspaper as well as Udayavani Kannada daily newspaper, Bangalore edition. Bangalore edition, as the petitioner is residing in Bangalore and the properties are substantial properties, all properties. Substantial properties are in Bangalore. The publication is to be filed on or before 7th of November, fixing date of appearance as 28th. 1 month after publication. 12th of December, date of appearance. Next item order. Madam, just a second. Pass an order, similar order. Dispensation in Madhya. Seal number 9 animbu. Seal number 9. I number 1 of 22. What is the value of the property? I number 1 of 2022 is allowed as the value of the property shown by the petitioner is 76 lakhs and petitioner is undertaken to pay maximum court fee payable under the Karnataka Court Petition Suit Violation Act. Under the circumstances, this court deems that the presence of the deputy commissioner is not necessary, hence notice to deputy commissioner is dispensed by allowing I number 1 of 22.
Grant of letters of administration by the wife and children is property. I number 1 is for dispensation, undertaking to pay maximum court fee. I number 2 is for citation, my lord. For citation.
I number 1 dispensation of notice similar order. What is the value of the property? 46 crores. Undertakes to pay the maximum court fee. And notice to deputy commissioner not required. Interstate succession or testamentary? Early seeking letters of administration. Petition is filed under section 278 of Indian Succession Act, seeking letters of administration in respect of assets of late. Sorry. Prabhat Undappa Amashi AMA SHI. Who died on
20th May 2020.
20th May 2020. 30th May.
20th May 2020.
It is stated that he died intestate. The petition is filed by his wife, 2 children. In this order, it is stated that the petitioners are class 1 heirs. There are no other class 1 heirs. Under these circumstances, this court deems it appropriate that notice relating to the petition seeking letters of administration is to be published in a newspaper by way of citation.
I number 2 for that, my lord. The Hindu Bangalore edition and Udayvani Mukti edition and Bangalore edition. The one copy very common.
Hindu Bangalore edition. Devani,
Bangalore and Mukti edition.
Bangalore and Devani.
Yes, Nagraj?
Yes. Yesterday's matter. Yes. You have gone through explanation. Court's your contention or court's view? Court's view. Your remedy is not yet lost. What you have to do is you have to file an appeal before SLP. No, that can't be done in review petition. See, unless maybe this is my view. Unless you question this judgment, filing SLP, probably you will not be in a position to file one more suit. You will be hit by principle of res judicata. The remedy is to file SLP. Whatever relief you want to seek, you seek that. In this review petition, the only question is whether we can take into consideration the subsequent change in interpretation of law that is impermissible because of explanation. Heard the learned advocate appearing for the petitioner. This court-wide order dated 4th February 2015, passed in RSA 1090 of 2011. Dismiss aita hai to airline. Dismiss the appeal. Where do you get it?
So far as relief of communication is concerned, the plaintiff shall point to prove allegedly interference normal in order of communication. The plaintiff now to show that there is
Now you can take advantage of this observation. You can take advantage. You will not say anything on that.
So anyway, but in case any future interference, but I
The
will.
scope of review is very much limited. Dismiss the appeal. While dismissing the appeal, this court has placed reliance on the judgment of the Supreme Court in Gurudwara Sahib versus Gram Panchayat Village Sirtala 2014 1 SCC 669. This court took a view that suit for declaration of title based on adverse possession is not maintainable in view of the aforementioned judgment. The learned counsel for the petitioner has filed the instant review petition, taking into consideration the change of declaration of law by the Supreme Court in the case of Ravindra Kaur Girwal versus Manjit Kaur and others. 2019 SAR Civil 945. Heard the learned advocate appearing for the petitioner. Learned advocate appearing for the petitioner would submit that in view of the subsequent judgment of the Honorable Apex Court, the suit for declaration of title based on adverse possession is maintainable. Under the circumstances, this review petition has to be allowed, and the judgment dated 4th February 2015, passed in RSA 1090 of 2011 has to be reviewed. The scope of review is governed under Order 47, Rule 1 of Code of Civil Procedure. Explanation to Order 47 reads as under. The fact that the decision on a question of law on which the judgment of the court is based has been reversed or modified by the subsequent decision of a superior court in any other case shall not be a ground for the review of such judgment. Stop. To exercise the jurisdiction under Order 47, as claimed by the petitioner, the explanation provided under the Order 47 would come in the way. Subsequent change in the interpretation of law is not a ground to review the judgment. Under the circumstances, there is no merit in the review petition. Accordingly, the review petition is rejected. Yes. Yes, sir.
I for the appellant, concurrent finding merits. The plaintiff, the mother of the first dependent in the rank of the party.
So dismissed or decreed.
The suit was dismissed for.
So plaintiff is an appeal.
Yes, madam. Plaintiff is an appeal.
What was the nature of the suit?
Nature of the agricultural property, madam. 3 acres. They are
Right.
not-
What is the relief sought?
Leaves of suit for declaration and the permanent injunction, madam.
Declaration of ownership.
Ownership.
On what basis?
There was a partition among the mother and the children. Out of, she purchased the property in the year 1966, sir. And
Who purchased?
the mother.
Ah.
Mother purchased the property in the year 66, madam. And there was a partition exhibit P2, the family partition. According to partition, this property is part of the share of the half of the 1.5 acres is part of the share of the son of the plaintiff.
Purchaser.
Purchaser.
See, if the mother has purchased the property, how she can effect a partition? Whether self-acquired property it is.
Meanwhile, the plaintiff was died, madam. The first son was the brought up like example PW1, madam. PW, the first dependent is the first son. The second dependent is
No,
the.
you understand, answer the court question. Mother purchased the property. What is the name of the mother?
Mother is the.
Channamadanika.
Devamma.
Devamma.
Channamada Nayak is the first son of the plaintiff.
All right.
She died during the pendency of.
Just a second. Devamma purchased property in
1966.
1966. All right. How many children to this
There
Devamma?
are 3 children, madam.
3 sons.
3 sons.
Okay.
The
So when she died,
the suit was filed in the year 92, madam.
when
Through
mother
the
died,
pendency of the suit was
who filed? Devamma herself filed the suit.
herself filed the suit.
All right.
And through the pendency of the, she died, madam. And the
Just a second.
appellant here is
Just a
not on
second.
record.
Just a second. She filed the suit in 1992, claiming ownership in respect of entire property purchased by her.
Yes.
Entire property purchased by her. Suit is filed against.
Against the 2 sons, first son and the second son was died, madam, in the daughter-in-law.
All right. What about the third son?
Third son is the, according to the plaintiff, she's along with, residing along with her.
All right. All right. Then she died during the pendency of the
It
suit.
is a share is
Just a second. She died during the pendency of the suit. Then what happened? Who came on record?
The first son.
First son.
According, she stated that the first son is along, the last son is residing along with me. According to exhibit B2, the 1 acre 30 gutta is given to his partition.
Forget about partition now. She died. She wanted declaration that the property belonged to her. She purchased the property in 1966. You are not disputing. So consequent to her death, who prosecuted on her behalf?
The first son.
First son.
He was not a party to the.
All right. Who was living with her? On what basis he prosecuted? Is there any will in his favor?
According to exhibit B2, there is a document. Family issue. That I am the only the dependent 2 and 3 are the other 2 sons, 1 son and the daughter-in-law. And I am only I am the successor of that. It's not on record. He was prosecuted.
He came on record based on?
Based on the exhibit B2.
Is it with the will?
Not the will.
What is that? What is that?
It's the
Partition.
partition. In that.
Just a second. In which year that partition was effected?
'69.
1969. And she went to file the suit in 1992.
92.
Just a second. Just a second. When she filed the suit in 1962, sorry, 1992, what she said about 1969 partition? She challenged it.
Yes, according to the property, I purchased the property in 1966.
What she said about 1969 partition deed?
Yes, he stated, according to that only the office given to my first son, and office for maintenance of my during my lifetime.
That's what she stated. So her suit was to seek a declaration that she has got half share by reason of 1969 partition deed or in respect of entire property.
Half is the son, half is the earl. The 2 recitals.
Read the prayer in the plain.
Then, madam,
Read the prayer in the plain. You're not answering the court question.
prayer of the
See, she filed a suit for declaration claiming ownership in respect of survey number 54, measuring 3 acres 30 guntas. What is the extent of property purchased by her? Then what is her reference in the, what is the reference made in the plaint relating to the so-called 1966 partition? 66 in another learn. 69.
Yes, no, she stated the another property was purchased from the first dependent. That is discrepancy regarding the extent of the property. But at page 9 of the easement of the trial.
So you are not answering the court question. She purchased how many acres?
3 acres 30.
She purchased 3 acres 30 guntas. She files a suit for declaration of title in respect of 3 acre 30 guntas.
Sorry, 2 acres 30. But into the sale deed dated 31/8/1996. Also the 2 acres 30.
Then how the extent is enlarged in the suit schedule to 3 acres 30 guntas.
It's the 1 acre what was purchased from the participant. According to the,
Which year?
is not stated purchase the property from the participant.
See, these are all obvious questions. You should be ready with the answer.
It is like that. It's not.
See, you have prepared this draft.
And my last,
So where is the challenge to the so-called partition of 1969?
meanwhile, the suit was partitioned because no, I am not the concurrent fighting. In the meanwhile, the suit was partition was filed. The finding of the given by the para level of the judgment the trial court is the either the plaintiff or the defendant not proved either the partition or the zone. So hence after death of the mother, now it is child property. Yes, they are entitled for.
The suit is dismissed.
No, no, this is now para level of the judgment.
Then plaintiff filed appeal. Suit is dismissed. Then who filed appeal? Plaintiff filed appeal.
PW1, plaintiff died, PW1 the mother.
Right. He is also plaintiff. He filed appeal. What happened to that?
Also,
Dismissed. What is your case now?
how the involved is subsequently with the pendency of the survey mela, they filed the suit for partition.
What happened to that?
That is and according to
Just a second. Your mother purchased the property. She has not executed any will. The property would devolve upon all the children. What is your case now?
now I will go.
Huh?
Because I go for the partition.
Yes. They have already filed a suit for partition. Please verify on the facts. This is the fact. Mother has not executed any will.
Okay.
Yes. Better to withdraw this appeal. No, you want an order.
Even the suit is filed in the year 2014, pendency of the judgment.
What you want?
You have the pendency of the display, I said my right there.
What is your right? Your right is 1/3 share. The learned advocate appearing for the appellant and learned advocate appearing for the respondent. The suit is filed case number 238 of 92 by one Devamma on the file of an affidavit. Which court? Civil Judge Junior Division HD Kote. Yes. The suit is filed for the relief of declaration of title and injunction. The suit is filed in respect of property bearing survey number 54, measuring 3 acre 30 guntas, situated in Eggadapura village, HD Kote Tal. During the pendency of the suit was filed by the mother against her two sons. The third son is not made a party to the suit. It is stated that the third son is living with the plaintiff mother. The plaintiff mother died. The third son who was living with her by name Chandramadana Naik prosecuted the appeal after the demise of plaintiff. The suit was dismissed. The trial court held that the title of the mother over the property or interest of the mother over the property fall upon 3 children. Accordingly, the suit is dismissed. The third son who prosecuted the suit as the law of the mother of Mother Devamma also filed appeal in RA number 96 of 2006 before senior civil judge Said appeal is also dismissed. The unsuccessful appellant is before this court. Second appeal. Stop. There is no dispute relating to the relationship of the parties. Plaintiff mother Devamma purchased the property in 1966. Died in 1992. Both the learned counsel for appellant and respondent would submit that mother died intestate. Under the circumstances, nothing survives for consideration in this appeal, and it is also stated that suit for partition is
Partition
pending.
in OS number
462 of 2014 on the file of
the Junior Division JMFC HD.
on the file of civil judge HD Kote. Full stop. Under the circumstances, the parties are to work out their remedies in the pending suit. No substantial question of law arises for consideration in this appeal. Accordingly, the appeal is dismissed. We should have withdrawn this appeal.
Now.
You should not, you should not have filed the appeal at all. Not this appeal, first appeal.
I advise to. That is the reason. Witness after the withdrawal. Yes.
All right. Yesterday's matter. All right. First respondent. Now, if the appeal is to be dismissed, Allah, if the appeal is to be dismissed, there is no need to bring the LRs. No, this is for admission, right? What happened? To declared or dismissed?
Because the question of law is not that whether the synthetic or one Srimati Malad is belongs to synthetic or
Belong to?
alias Santan law is synthetic cover.
That means what? That means what? That means what?
Synthetic cover means they don't have female heirs. She don't have a daughter. So it continues that way. So while allotting partition, the person who has no female issue, then she will be allotted only a limited right, life interest. And that will, after her death, will revert back to the synthetic cover. That who has the family who has got the.
Notwithstanding section 14 of Hindu Succession Act.
That is the only point, Malad. Because
Section 14 of Hindu Succession Act has got overriding effect.
that is the point to be decided in this case.
Not applicable. Huh?
There is some.
There is judgment. So that's in favor of you or against you? At the request of learned counsel for the request of learned counsel for the appellant and respondent, this matter on Friday.
Friday. But in the meantime,
Saturday is a working day. One more option. Thank you. Friday. Friday.
Accommodation.
2012 matter. You don't want your matter to be admitted. You want your matter to be admitted, you argue. You argue the matter. 2012, 10-year-old matter for admission makes no sense to adjourn the matter. Sorry? Then again we will dismiss it. Is the matter. On what basis is not declaration of title? All right. You sought against whom? No, that is understood. That is under relationship. Strangers.
But my sole property is Melan, but then number 750 bar 4.
What is the extent of your land? Boundary? Now, how you acquired this land? How your ancestors acquired? So for last 100 years, you have got revenue entries in your name. And consistently, there are mutations after the death. Yes. They purchased sorry, number 17. Yes. Now, what is the extent of their land? Your extent? Possession is also granted, no? So possession in respect of how much extent? So entire 2 acre is in their possession. There are how many subdivisions in Surya number 79? How many subdivisions in all?
They enter into an agreement. Protect this land. 80 lakhs. And there are paid some amount.
To you.
And now my land after admitting this appeal, my land is back.
You produce that document as a additional document. You are ready to sell the property.
Yes, I am ready to sell the property.
No, just a second. How much? You have admitted the ownership. How you lost possession of 2 acre 19 muntas? No, it's a vacant land. How you lost it? What were you doing? Set it all right, but what were you doing all these days? When they purchased?
They are purchased in 1948. And this is part 9. Yes, schedule.
You have not filed a suit for specific performance? Allah. You are ready. You are ready. So if you produce the document, if they admit, well and good. If they dispute, then the consequence. If they dispute, the document has to be proved. Additional evidence. file application. See, if you have agreed to purchase the property, just pursue it. If the document is accepted, that goes against you. You are admitting the ownership. They've already paid 6 lakhs. Through cash or check?
80,000 they have paid. They have paid cash.
At the request of current counsel for the appellant, Justice Medron. Next Friday. You file application along with original documents. File along with original document, with additional document. Is there a recital that the original is with them? Is there a recital in the agreement that the original is with them? Yes. Next week. All matters. This is comparative. We have got 2006 matters waiting for final hearing. The request of on Monday.
Serial number.
Yes. Special performance. Granted or refused? Granted or refused? Refused.
Divergent finding, your trial court refused. Appellate court reversed.
Yes. Date of agreement? 4/4/2005. Consideration amount? Agreed? 175. How much advance paid? 40,000. What was this time stipulation for balance payment? 2 months. When the suit was filed? Eleven one 2007. Extent of land? 15 acres.
3 items. Totally 3 items.
All right, 15 acres
3 acres.
for 175. All right. Who executed the agreement?
In favor of plaintiff and second.
Second defense. What is the relationship between plaintiff and second defense? How it is permissible? Agriculture land in favor of persons or not family members.
I can't remember.
Not permissible. You agree on this point? But law is very clear. Which section, sir? Which section? Land Reforms Act. Different families cannot purchase agricultural lands together. Which section? What is the finding of the first appellate court on that point? It was raised. Payment executed. Admitted,
Admitted, execution is admitted.
admitted.
The contention is that I am not the agreement holder, I am only a broker. That is the contention.
He is not the owner.
Plaintiff is not an agreement holder. Even though
All
I am
right.
not. The contention of both the defendants that I am a broker, I am not a. That is the contention. The contention accepted.
So
by-
payment of rupees 40,000 admitted. How it is paid? Why balance amount is not paid?
He was ready. He approached the first defendant.
What is that to show that he was ready?
And document 6/6/2005. The pay deed executed by first defendant in care of the 2005.
Same property.
For 2,28,000.
So that is 2 months later.
2 months later.
Entire property. 15 acres. So he didn't join you.
They at the back of the plaintiff. The first defendant and second defendant joined together.
So first you have to satisfy how these 2 persons who are from different families.
So that aspect, not examine it. You one share that.
Discuss Agilo. This point is not discussed.
Not
You are nodding the head when I mentioned. There is one provision which says land reform.
79A, now 79A and B is not there.
It was there at that point of time.
That's kind of it.
Defendant number 2 participated in the proceeding. Purchaser. What is his defense?
So he entered agreement with B. That is a registered document.
Not so. Somewhere in city.
I will accept it.
You had 10 years time to examine all. Sorry, 6 years time. You need to pay the amount. You need to pay the amount. You received 40,000.
Living partner.
Partner or dependent ಬಂದಿಲ್ವಾ?
First dependent ಬಂದಿಲ್ಲ. Owner ಬಂದಿಲ್ಲ.
ಬಂದಿಲ್ವಾ? Before the trial court? ಇಲ್ಲಿ ಬಂದಿಲ್ವಾ? The first appellate court passed a decree for refund of the amount?
ಇಲ್ಲ.
There is one specific provision. The bars persons from 2 different families holding agricultural lands together. Is there evidence relating to readiness and willingness? Plea idea? Plea. Plea na ilva? Read the plea.
There are three.
Read.
The certificate is the owner of the subsidiary property. The certificate is the certificate in favor of the plaintiff and city litigant on 4th April 2005 in writing for sale consideration of by executing a registry. I received balance sale consideration of ₹1,35,000 within 2 months from the date of the at the cost of the plaintiff and secretary. In the last week of plaintiff, when the plaintiff approached the first certificate to ask for the convenient date to execute the registered setting, the first certificate has said that she will not be in a position to come and for another 3 months to be legal that for after 3 months, when the plaintiff asked the second certificate to accompany him to approach the first certificate, the second certificate has dragged on by one pretext or another for about another 3 to 4 months.
Yes. Then
Later on, I came to know that
is not readiness. In the plaint, you must assert that you were ready, you are ready, and you will be ready. It is not there.
para 8.
Good.
The plaintiff was and is always ready and willing to perform his part of the
Real. There's a plea.
No, that was statutory and procedural by law.
Right? The question was whether the plea was raised in the plaint or not. You said no such plea.
And they didn't open the document. When
You understood the question. Court question is whether such a plea is raised in the plaint or not. You said no. You are so emphatic. You can't be so casual when the court puts the question. There is plea, you say that there is plea, there is no evidence. You can argue that this is not readiness and willingness not established. The court question is very clear, whether the plaint government is there or not. If there is no such plaint government, I wanted to dismiss the appeal right now. You said there is no such plaint government, that there is an government. See, that was the question. What was my question? What was my question? If there was no such government, I wanted to dismiss the appeal right now. There is no need to go further. I trusted your submission. So ask them to read. So when will you get ready? The request of learned counsel for the appellant, Justice on 20th. See, there is a provision which says if the members or persons are not from the same family, they can't hold agricultural lands together.
The 27, Rita. Rita.
Also.
My lord, in the previous matter, I was muted. I was come to Dharwad bench, my lord, the document kindly grant some time.
Dharwad bench? Why?
Suddenly list.
Your case is listed in Bangalore bench.
Case division bench.
27.
27. Next week I can do
At the request of learned counsel for the appellant, who is now said to be in Dharwad bench. Justice Metron, 27.
Much obliged. Much obliged.
Sorry? No, you have to refresh my memory. Yes. What is that?
The document and about that, extending is very less for
Manish Murray number. What is that? So your extent is more in the plane compared to what?
It's shown here.
Yes. Then, it doesn't look like so 1 gaja means so many feet. So then comes to 48. So 14 into 3. So that comes to 14 into 3 is set. 48 into 42, sorry. 42 into 36. Great, huh? So that tallies.
Of course, 14 into 36 is there, but the schedule runs what is there. 18 into 42.
Again erroneous.
East to west.
East to west how much? No, in your plane, east to west. So if you take it as gaja, 14 into 3. 42 aಗುತ್ತೆ. Then
north to south 42 ಅಂತಾರೆ. North to south 36 ಆಗುತ್ತೆ.
you are coming 42. So there is a mismatch in any case.
The thing is, if like not evidence, they say that 41 and 42 both one is minus. And that's the extent is not as imaginary extent. And that's almost varies. Except whereas as the last of the only 36 and then what we going to do. And even in the repetition also there are they also there are the same measurements. Given. Changing the grant of Patra made into
So the Sarkopatra itself is not produced.
yeah.
You challenged it. You challenged it.
Yes, we have challenged that's the grant of Patra.
You have not produced it.
No. That's
See, if you challenge a document, it is your responsibility to produce a document. Maybe the document belongs to him. Virtually, you have challenged it. So what is the basis for you to file a suit? Direction issued in the writ petition. Why the writ petition is filed? Challenging the grant. So grant order you have not produced.
but they have laid on the grant of because not as examined in that point.
Remand the matter. Rectify your mistake. You rectify your mistake before the trial court. Extent is not correct. So even if I accept your contention that it is 14 into 12 of gaja instead of feet, then also the description doesn't tally.
Description 42 is not description of move on and cash for extra. 14 into 12 into 14.
14 into 12.
14 into 12.
The 14 east west. Well north south.
Even it is not their case matter. Rahul property belongs to them. And when the injunction has attained finality and they are not challenged the.
There's too technical now. See, what has happened is, being a respondent, they could have challenged the finding on a particular issue, right? No, not necessary to file a cross objection, right? Now you filed an appeal. That judgment went in your favor, right? So the judgment of the trial court merges with the judgment of the appellate court. Now they have challenged judgment of the appellate court. Appellate court as well as trial court. See, it merges. See, before this court, they have challenged both the judgments.
Only judgment of RA is
First appellate. We have challenged judgment of first appellate.
For injection is concerned, the very penalty. For speculation of field is concerned, presumption of mountain and the appellate court rely on mountain of business act. Because they did not, burden is on them. It's true that they are not owners of property. They are not charged it. Therefore, the appellate court rely on mountain.
But just the first appellate court, the order of.
Who drafted this appeal? You drafted. Who drafted this?
Order of the trial court is credited as with respect to the declaration, and declaration is granted. As such, it merges with the order of the trial court.
What was the first appellate court?
Judgment and decree of the trial court so far it makes the hereby satisfied. And that the plaintiff is the owner of the court property.
Declaration is granted. Injunction was granted earlier.
Virtually merges with the order of the trial court. They sought to release in the suit.
Understood. It merges with the order of the trial court. It's not like that. Trial court order merges with the order of the appellate court. So why is the challenge to the trial court order in the appeal?
They're not showing anything pertaining to the order of the trial court.
There is your appeal memo.
Page 11.
Order of first appellate.
Is it vacant site? Is it vacant site? City security. See order 41 rule 33. So what we will do is, we will say that you are in possession to the extent of 14 into 14 into 12. 14 into 12. Yes. Now, whether it is yards, gaja, or something else, it is to be clarified by the. It doesn't even say gaja. How do you say that?
Another document is there that of course it's not executed. Our document must be
Gaja. Gaja.
Also the name of the
So 14 into 12, we'll verify that. Gajan. It's 14 into 12 gajan verify ಮಾಡ್ತೀನಿ. No, we'll clarify. It's 14 feet into 12 feet. 14 feet east west, 12 feet north south. Sorry, yes. As shown in exhibit P2. That boundary, if that boundary exceeds the extent mentioned in exhibit P2, what to do? Forget about their omissions. Forget about their omission. Your own title, you filed a suit for declaration of title. You must establish your title. You can't stand on his weakness. Understood? No, court is acknowledging your possession in respect of an area measuring 14 into 12. Whatever. 14 into 12, not beyond that. So injunction is going to be granted, but it may not be with respect to the same boundary which you are shown here. Then we will appoint a court commissioner to measure this 14 into 12 space. They can submit the report. Let the property be surveyed. So because of his default, you cannot have a degree for declaring your ownership. There is no title deed as such.
Or by accident.
So is he adjoining holder? Is he adjoining?
He's not paying the
Get about it. Are you adjoining holder? In your case, it is granted to you. The grant is not produced.
Basically, if you don't pay the they are not paying this property. Their property rented is
119, 111,
Yes.
119.
Already is,
That is understood.
coming to this number, is he is not selling, because he has not paid any override. Saying that it is my property. But that the trial court observes. He has not paid any. Saying that some property comes to me.
But they say that in the order of the recognition, the plot that has been granted to me, one such relate to them, is punishment number 41 and 42. And I have been allotted a plot in their property by giving a kata number 119/1. That is what the contention of them in the recognition.
Just a second. Are you saying that the property belonging to them is granted to you? Are you saying that the property in their possession is granted to you?
I apply for a grant, they grant me a property with a kata number of 119/1.
But it's not this property.
Then I start constructing, I apply for license to construct a house. Then they go to the Jilla Panchayat, they have filed a revision petition stating that the property granted to.
All right. There is obstruction. What you are supposed to do? Then
As well as, thereafter, they were reverted back to trial court to file a stay.
what you have done? But this is residential house, no? No. What is your instruction? What is your instruction? ಬರ್ತಾ ಇಲ್ವಾ? Yes. ನಿಮಗೂ ಕ್ಲೈಂಟ್ ಬರ್ತಾ ಇಲ್ವಾ?
Petition order, page 4, the contention was by the petitioner, the respondent, the boundaries of the plot granted to the respondent is known to the east, bottom and land on all other sides. The petitioner claims that the boundaries of his property is also the same. The boundaries are not clear enough to examine and decide whether the respondent's property is the same as petitioner's property. If the petitioner has any grievance in regard to the title of possession, it is always open for him to file a suit.
She filed a suit. You did not contest. You won. And even your appeal is defective to a certain extent. So don't challenge the trial court judgment.
So the appeal, the first appellate, the entire.
Don't understanding the point. Maybe because court has used that word. Have you understood the concept? So what? Are you not supposed to challenge the judgment of trial court which is against you? Have you challenged? Then Parliament. Other dictation ಆಗಿತ್ತು. Exhibit P1, sorry, P2, the register maintained by the Gram Panchayat reveals the name of the petitioner at serial number, name of the plaintiff respondent at serial number 1. The extent of the land is mentioned as 14 into 12, 14 into 12, and thereafter the word Ga is mentioned, Kannada Ga is mentioned in the next column. The learned counsel for the respondent would also invite attention of this court to one more document, that is the certified copy of. What is this? Certified copy of the tax paid registers pertaining to the suit property. In that document, the word Gaja is found in column number 9. Though this document is not marked, this is the document issued by the, it's a public document, the court would place reliance on this document. And from this document, it is apparent that the extent of the property is 14 yards east-west and 12 yards north-south. However, the plain schedule property, extent of the property mentioned in the plain differs from what is mentioned in Exhibit P2. Under these circumstances, this court is of the view that the judgment and decree passed by the trial court is to be modified in exercise of powers under Order 41, Rule 33 of CPC, verifying that the plaintiff is in possession of 14 yards east-west and 12 yards north-south. Which village are those? Of Vanarasi village. So and so Hubli, so and so Tala. With this modification, the judgment and decree passed by the trial court is confirmed. And it is made clear that if the appellant is granted any land in respect of property bearing number 119/1, this decree will not come in the way of said grant. If the appellant is able to establish the grant, alleged grant in his favor. Confirmed with this modification. So your claim is your property is 119/1. See, you have not done anything. You have not done anything. This last observation, the fact is not due to you. No written statement, no proper appeal, nothing. Huh? Yes.
Under 110 not be according to them as they created it an ancestral property.
See, what is your stand? I will go by your stand. You said the property belongs to Chinnappa. Then it is not your property. Then Chinnappa says, no, it's not my property, it's plaintiff's property. Then who are you to say? See, it is not your property. You say it is Chinnappa's property. Chinnappa says it is plaintiff's property. Then what is your stand? See, your apprehension is to be taken care of in case if you file a subsequent suit or a proper suit in the form of declaration of title based on the alleged grant. Grant order is even not produced even this court, before this court. You say indeed for everything and you want an order. You don't want to do anything and want an order in your favor.
Respect to the property of Khata number 119 of.
So what is to be done for that? What is to be done for that? The property is granted to you. So why don't you file a suit for injunction based on that alleged grant? So you want me to go to write that particular thing also in the order to say that you are entitled to file a suit for injunction or declaration, whatever. Advise your client properly. And this is not the way to file an appeal. This is not the way. See, ideally you should have filed an application for production of that alleged grant order. That is not done.
Where in the
Oh, sketch. Your land is 27. So what is the consequence of that?
That is the survey is adjusted to earlier the as per the 26 survey. Both the age in the return statement as well as the paint also the 26 is the expressed by the both the parties admitted. But by on the survey malad, it is overlapping with the survey number 31.
You filed a suit for dispute of 47/1, 47/1. Yes, Prakash, your land is 27. 27 it is not adjoining. There is also adjoining. It's not adjoining. Where do you get survey number 27 in the village map? That's adjoining to 26. Has to be alva. Ah, yes. Yes, 27 is not adjoining to 47. Yes. Your allegation is he has encroached. Suit for possession. Now the report says there is encroachment by. Report doesn't say, last report doesn't say that there is encroachment in survey number 26. The report is apparently incorrect.
31 survey number 31. He encroached and cultivated 2 acres as another is 20.
Who? That one belongs to whom? That one belongs to whom?
That is the government land.
That's not concerned to you. So your contention that 35 gunta is encroached by dependent is not established in your village map. That is incorrect. You compare this survey sketch and the village sketch. That is incorrect. He says survey number 27 is adjoined to survey number 47/1. That is not the case.
It is also the 27 is not adjoining to my land. In between 26 are there, but the survey is overlap.
How do you establish? Now only way to establish the alleged encroachment is through survey report. Survey report prima facie incorrect.
Second report, is the 26 guntas. The third report is this commission is appointed by the dependent itself by an application and got appointed the commission.
So even this report, this is exhibit C1. The report says survey number 47/1 is adjacent to survey number 26. That is not correct. That is contrary to the village map.
What the evidence of this survey by the BW says that the survey number 26.
That means survey number 26 belongs to whom?
Government.
Government has encroached. Government has encroached in your land.
Government has not, but there is no government they cannot enter because he is the continuation he can
So that is incorrect. See, you are referring to the report of the surveyor, which is contrary to the village map. Now you establish that village map is incorrect. How do you establish that?
There is some description in the village map.
Surveyor's statement in the cross-examination that village map is incorrect cannot be accepted to say that village map is incorrect. There has to be a challenge to the village map. Who has challenged it? Then, see, village maps are notified. It carries presumption. You are not challenged that. The survey report is contrary to the village map.
the survey is conducted. Even the village map also prepared on the picture of the survey report.
You admit the survey map now? At least you are not questioning the survey map, village map. There is no challenge to the village map. Then how to discard the village map which is not in question? Why the court should not follow the village map, which is of antiquity?
But survey say, I mean, my court is affected by only 10 members having thereafter, another survey is conducted after the proceeding of the.
Just a second. The third report, you are objecting to the third report. You filed objection and you filed cross-examine the commissioner also. Sir. Mandilwa. Prakash. Cross-examine. Or Mandilwa. You are not. All right. Village map. Yes. No, in this case, the only piece of evidence is survey report. Survey report is incorrect. It is contrary to the village map. The court can't accept the survey report. Not established.
There is a based on the village map, there is a small description in the survey. Because of the survey number overlap. That mistake will be rectified by the competent authority. But here we are not made an application to.
Who has to rectify that? If the department doesn't do it, then who has to do it? Any person who is aggrieved by the erroneous map has to do it. Did you take steps? See, as long as survey map is mistaken, the survey village map is not rectified. Every surveyor is bound to follow it. It is not rectified, it is rectified in a manner known to law.
Already the cash to submit the report to the government.
Then if he has not done, what should be done? Yes, somebody who is affected by that erroneous map. Yes. Yes. Now you know what to do. So sitting in this section 100 jurisdiction, this court can't say that the village map, which is not in challenge, is incorrect, right?
Can't challenge that village map.
You can't. In this suit, whether you could have challenged it or not, there's a different thing. Whether this court can say that the village map is incorrect, then that is not in challenge. The court can't say. And that is the case, whether the court can say that this report is correct, it is contrary to the village map. Now you know what to do. So all these years, unfortunately, this client is not properly advised. Sorry? That opportunity is always there. No. If you are able to show that village map is not properly done, and if there is a pursuant to that, there is an order to rectify the village map. And after rectification of village map, if he is found to be in possession of your land, then he will be entitled for possession. Now, if my view is correct, you should allow me to dictate the judgment.
Suppose I am not putting number to establish this, but I am doing the land.
No, this court is not saying that the village map is correct. The court only says that the survey report is contrary to the village map. If you are able to show that before an appropriate proceeding in an appropriate forum, that the village map is incorrect, then consequences will follow.
But, suppose once again I can't make citation.
You can file, you can file. No. This matter is decided on a question whether you are in a position to establish that the present survey report is correct and whether the dependent is in possession of your land. Yes. This court, I can certainly say that anything which is decided in this case will not come in the way of you taking appropriate steps to challenge the village map.
Suppose, reserve for
There is no question of reserving the right. The right is always there. If the village map is erroneous, any person who is aggrieved by the erroneous village map can question it and seek the appropriate action for take appropriate action for rectification of village map. That right is always there, provided that village map is incorrect. This court is not going to say that village map is correct or incorrect. This court is only going to say that the report of the court commissioner is contrary to the village map, which is not yet challenged. I can note your submission that the village map is incorrect, but I can't give a finding.
I am using here regarding the entire shooting plus on the survey report is contrary to the village map. I want to establish that survey village that.
Who prevents you? Who prevents you? This court judgment won't come in the way. That village map is not under challenge at all. Why should I remand? Village map is not under challenge at all. Now, where is the scope for remand? I thought you understood the point. See, if the village map is incorrect, you have got a separate remedy. So who prepared village map? Then who can rectify it? If they don't do it, who has to move them? Agreed person. Then have you done it? Are you prevented from doing it by this judgment? Are you prevented from exercising your right by this judgment? No. That's misconception. That's misconception. Heard.
But this proceedings will be the share of this purpose is also the purpose of what about the God purpose consider already or challenging the same.
No, that apprehension will take care of. Mr. Prakash, we'll observe if he is successful in challenging the village map and consequently, consequently after rectification, we don't know whether the village map is correct or not, we don't know. Maybe it is correct, maybe it is not correct. If he is able to establish that the village map is incorrect, and if he is able to establish consequently that you are in the possession of the property as an encroacher, then the remedy is available to him. That we'll only observe that. That's all. We will only say that the judgment will not be adjudicated. Third, the learned advocate appearing for the appellant and learned advocate appearing for respondent. Only one appellant and one respondent.
Appellant is one, but here the right and member is another.
Nevertheless, they are all appellants. Concurrent finding. Suit in OS number 238 of 1990 on the file of Munsif Sagar was filed by one Lingappa Gowda, son of Manjappa Gowda. The suit is filed in respect of survey number 47/1 of Gulehalli village, Taluk Sagar. Stop. Plaintiff has sought a declaration that he is the owner of this said property. What is the total extent? The total extent of the land is 2 acres, 28 guntas. Stop. It is the contention of the appellant plaintiff that 35 guntas in the said land is encroached by the defendant. It has also sought a relief of possession and the mean profit against the defendant. Relationship in order. The defendant contested the matter. Defendant disputed the contention of the allegation of encroachment made by the plaintiff. Defendant contended that the suit is filed in respect of survey number 26. Your contention is 26. Sorry. Defendant's contention is that he is the owner and in possession of survey number 27. And survey number 27 is not adjoining to survey number 47/1. It is separated by a stream. And survey number 26. Hence, there is no question of encroachment by the defendant is the contention of the defendant. Stop. The trial court, considering the nature of the dispute between the parties, appointed a court commissioner. Prior to the filing of the suit itself, there was a report which indicated that the plaintiff has, defendant has encroached 10 guntas. 10 guntas. Now, plaintiff amendment. Initially, the suit was filed seeking relief of possession in respect of 10 guntas. During the pendency of the suit, the court commissioner was appointed. The court commissioner submits a report stating that there is encroachment to the extent of 26 guntas. Again, the plaint was amended pursuant to the report of the court commissioner, subsequent to the report of the court commissioner. Thereafter, one more commissioner was appointed to measure the suit properties, and the suit property was measured by the court commissioner, and the report is submitted, which is marked at exhibit C1, C6, C6. What is the third report? C6, full stop. The report at C6 reveals that survey number 27, survey number 26, survey number 27 is adjoining to survey number 47/1. Full stop. The trial court has decreed the suit placing reliance on exhibit C6. Full stop. The defendant preferred an appeal challenging the said judgment and decree before Senior Civil Judge Sagar in RA number 66 of 96. Full stop. The first appellate court accepted the contention of the defendant appellant. The defendant appellant contended before the first appellate court that exhibit C6 is erroneous, and he has filed objection to the report of the court, third report of the court commissioner, third report of the survey commissioner, and accepting the contention of the defendant appellant, the first appellate court allowed the appeal, set aside the judgment and decree passed by the trial court. Full stop. Challenging this divergent finding, the plaintiff is in before this court in this second appeal. Yenanthiremagira substance.
Whether the lower appellate court had erred in setting says that the Easement and duty of the trial not pay any right to the property. Second, whether the lower appellate court had erred in
The appeal was admitted on 1/12/2010 to answer the following substantial questions of law. Here are questions. The learned advocate appearing for the appellant would submit that exhibit C6, the report submitted by the court commissioner, is clear in stating that 35 guntas of land survey number 47/1 is encroached by the defendant. As such, the first appellate court could not have rejected the C6 commission report when there is no serious challenge to the report of the court commissioner. Stop. It is also a submission that the defendant is not claiming any right over survey number 47/1 under the circumstances. 47/1, and his claim is only in respect of survey number 27. Under the circumstances, the decree for possession in respect of 35 guntals of land granted by the trial court in survey number 47/1 could not have been set aside by the first appellate. Next part. Learned counsel Sri S. Prakash appearing for the respondent defendant would contend that Exhibit C6 is contrary to the original village map. Would further submit that the original village map marked at exhibit. Mark original village map. Original village map D1. Original village map marked at exhibit D1 would clearly reveal that survey number 27, which belongs to the defendant respondent, is not adjacent to survey number 47/1, that is the suit property. It is far away from survey number 47/1, and survey number 47/1 and survey number 27 are separated by a stream as well as survey number 26. This contention of learned counsel S. Prakash appears to be correct in view of exhibit D1, which is the village map. Village map in this case is not called in question. When this village map is when this disputed commission report at exhibit C6 is juxtaposed with village map at exhibit D1, one thing is apparent, that the court commissioner has found that exhibit found that survey number 27 belonging to defendant is adjacent to survey number 47/1. So this report apparently is contrary to the village map. As already noticed, there is no challenge to the village map. Under these circumstances, this court is of the view that the first appellate court is justified in rejecting exhibit C6, the report of the court commissioner, which is contrary to the village map, which is not called in question. For the aforesaid reason, this court finds that the substantial question of law framed above have to be answered in favor of respondent and against the appellant. From the materials placed on record, it is apparent that the dispute between the parties is relating to the boundary dispute, and it is the submission of the learned counsel for the appellant that he should be permitted to question the correctness of village map, because the court commissioner has given an evidence stating that the village map is incorrect. This court cannot adjudicate as to the validity of the or correctness of village map in this appeal. Merely because the court commissioner has said that the village map is incorrect, the court cannot give a finding on that in the absence of a challenge to the village map. The village map is really incorrect, and in case if the survey number 27 is adjoining to survey number 47/1, it is for the appellant to seek appropriate rectification of village map, and thereafter he may have to establish the least encroachment by the defendant respondent. If the appellant is able to challenge the correctness of village map in an appropriate proceeding, and thereafter he is able to establish the least encroachment, it is always open to the appellant to seek appropriate relief of possession against the encroacher, subject to all just exceptions allowable under law. However, it is made clear that in such an event, the finding of this court should not be construed as a finding relating to should not be construed as a res judicata to the reliefs which is sought to be claimed by the appellant in a subsequent proceeding. With these observations, this is held that there is no merit in the appeal. Accordingly, the appeal is dismissed. For what? Just a second. An application is also filed for production of additional document, namely the registered sale deed in favor of the present appellant. This court has produced this sale deed this production of sale deed at this stage is not relevant, and the sale deed would not come to the rescue of the appellant to accept his contention, to accept the contention of the appellant, because the entire case is revolving on the survey sketch, and survey sketch produced by the surveyor is held to be incorrect in your the village map at exhibit D1. Accordingly, I number one of I number so and so miscellaneous number so and so is rejected. You just need to return the original sale deed to the appellant by retaining the copy of it.
I represent the respondent number 1 in this matter, Your Lordship.
Yes.
It was heard yesterday in
Yes,
part, and
Yes.
I was asked to submit whether it could be whole of B schedule cannot be granted. In fact, the appellant is only a purchaser list pendants, and the second respondent, who is my brother, has filed. He has not filed an appeal, but he supported my case. So whatever it is, whatever right my brother has, that is his vendor has, only that right the appellant would get. Since he has not challenged, then reduction of the area.
When the property was purchased,
So those details, but he himself admits that it is list pendants, Your Lordship. I'll just make a mention. But another this thing is, it was the partition was in the year 1988. I'll just mention here 1988, and in 2003, the first defendant, that is my brother, he stopped water and access to my land. So I filed a suit, and after 2003, this is purchased, because the vendor himself says that he has purchased it after the in fact, in his writ petition, even in this appellate in the appeal memo also, I don't find the date of purchase by the. If I stand corrected, it is 28/6/2007. Your Lordship.
Madam, you filed the suit.
Yes, I filed the suit.
Then you implemented him.
No, yeah, I didn't imply. I filed only against my brother in 2003, because he purchased it only on 28/6/2007. Your Lordship.
All right. When he came on record?
He came on record. But purchases only during the pendency of the suit.
All right, madam.
Yes,
When he came on record, at your instance or on his own?
That is not mentioned here, but I'll make a submission. He got himself impleaded to the suit by
all right.
Got himself
so he was permitted to. So he was permitted.
Yes, he was permitted. That I'm not on that. On whether he would get a right bigger than what his vendor gets in the regular appeal. In the regular suit was decreed, the appeal filed by both of them. Both of them filed an RA, and RA came to be dismissed. But his vendor.
Madam, your submission is not correct. Only second defendant filed appeal.
Oh, sir. Yes, yes. Yes, the second defendant, yes. Second defendant. So, as it stands, he was satisfied with the order which was passed in OS.
Who is satisfied?
Yes, OS
who is satisfied? Who is satisfied?
My brother, that is the first, second defendant here, second respondent here.
Do you mean to say?
Yes.
No, do you mean to say that the purchaser who has purchased the property during the pendency of the suit has no right to file an appeal?
He has not right. He has no right, but he does not get a bigger right than what.
That is not. Are you saying that he has no right to file an appeal?
No, I'm not saying that, Your Lordship.
Yes.
Only said
So he has filed an appeal. No, yes. Just a second.
Yes.
He has filed an appeal.
Yes.
And his appeal, what happened to his appeal?
His appeal was dismissed.
Dismissed. Now he has got the right to file
the regular second appeal.
Yes, he has got right to file regular second appeal.
Yes.
Right. So he has purchased the property from his your brother.
Yes.
Point number 1.
Yes.
Right. all the rights that are available to your brother are available to him.
Yes, yes.
Right? It is his contention that your claim of easement is so vague. You don't even mention the extent of land over which you are claiming easement. Length of the road is not mentioned.
Length
Width
of the
of the road is not mentioned.
is mentioned in the state, and photographs have been produced.
Just
by
a second.
Yes,
Just a
Your
second.
Yes, Your
In the description of the plain schedule,
Yes.
the length of the road, width of the road, location of the road is not mentioned. And according to him, the extent of land is nearly 4 acres.
That, no, it does not measure 4 acres, Your Lordship. Schedule B.
How many acres?
It was only 1 acre, 23 guntas.
All right, 1 acre, 23 gunta.
Yes. And
Where
it is-
exactly,
it is
where
a-
exactly the alleged road runs, according to the plain
runs
schedule?
to the east of
Where do you get it? Where do you get it?
east west, Your Lordship, at Schedule A, Your Lordship. Your Lordship may see Schedule A. To the west is survey number 44 and 45. In Schedule A. In fact, it runs at the edge of his survey number. I have
Where do
produced
you-
photographs. I have in the in the suit, I have produced photographs.
Yes, read Schedule A, read Schedule A.
Yes, Your Lordship. Survey number 43, measuring 3 acres, 6 guntas, situate at Agasavalli village, Shivamogga Taluk, and is bounded by east. Survey number 42, west 44 and 45, north 41 and 42, south by Kanihalla
Canal.
Canal.
Yes,
Yes.
yes. Now, where you are claiming easement, the property
is-
of dependent in Schedule B.
Yes, that is
Read
at
Schedule B.
at the
Read Schedule B.
survey number 44, measuring 1 acre, 23 gunta, situated at Agasavalli village, Shivamogga Taluk, assessment number so and so. Survey number 45, measuring 2 acres, 8 gunta, situated at Agasavalli village.
All right. Now, what is the extent of Schedule B then? 3 acres, 31 guntas.
If Your Lordship feels that it would be an extent, this thing, I may have to put it across to my client, because I've not been able to contact
Madam,
him in one.
Schedule A belongs to whom? It is the dominant heritage.
Dominant heritage is my this thing, because I am
Which is your schedule? Which is your schedule?
My schedule is for 43.
That is Schedule A.
Yes, Schedule A.
All right. Now you are
survey
claiming
number-
easement. Just a second. You are claiming easement in Schedule B.
Yes,
The total extent is 3 acre, 31 guntas, comprised in 2 survey numbers.
yes. Survey
Where exactly you are claiming easement of right of way?
I have said I've said it was, I've been using the extreme part that is which adjoins the road, Your Lordship. I have produced photographs to show that this is the path which I've been using, and there has been no cultivation in that area at all, which is visible in all the photographs produced by me.
Where is the reference in the plain relating to the length and width of the road?
It's a little vague. I do concede. That is why I'm saying
So,
across to my client.
What we will say is this decree for injunction granting right of easement without showing the description is impermissible. If you have got right of easement, you are permitted to file a fresh suit describing the exact length and width of the road.
At least if I put it across to my client, if he agrees to a lesser extent and it is specified.
Heard the learned advocate appearing for the appellant and the learned advocate appearing for the respondent.
One. Respondent number 1.
Respondent number 1.
Yes.
Yes. The appellant in this case is challenging the decree for decree granted by the trial court declaring right of easement over the land of the defendant appellant in OS number 43 of 46 of 2003 on the file of first additional junior division, Shimoga.
Yes.
The brief facts, the appeal filed by the second defendant appellant is also dismissed, confirming the decree, judgment and decree passed by the trial court. The appeal in RA number 128 of 2009 on the file of senior civil judge, Shimoga. The brief facts necessary for adjudication of this case can be summarized as under. The plaintiff and first defendant are brother Salva.
Yes, sir. Plaintiff
So the-
and second
First defendant.
First defendant. In the original suit, yes.
So this, the suit is filed in respect of two scheduled properties described as Schedule A and Schedule B. Schedule A measure is bearing survey number 43, measures 3 acres 6 kuntas in Agasavalli village in Shimoga Taluk. Full stop. Schedule B property comprises two survey numbers, bearing survey number 44, measuring 1 acre 23 kuntas, and survey number
45.
5, measuring 2 acre 8 kuntas in the aforementioned village. Full stop. Admittedly, the suit Schedule A property belongs to the plaintiff and Schedule B property belongs to the first defendant. Full stop. It is stated that the second defendant purchased the suit B schedule property from the first defendant during the pendency of this suit. Thereafter, he has come on record as the second defendant. Stop. The plaint says, on reading of the plaint, it is apparent that the plaintiff is claiming an easement of right of way, the property belonging to the first defendant, which is now purchased by the second defendant. Admittedly, the extent of road and the width of the road in the property belonging to the defendant over which easement is claimed is not mentioned by the plaintiff in his plaint. The trial court as well as the first appellate court have not considered this particular aspect and have granted a decree for injunction, a decree declaring the easement of right of way in favor of the plaintiff and also granted a consequential relief of injunction in favor of the plaintiff. This court has admitted this appeal on 22/11/2010 to consider the following substantial question of law: whether the courts below have erred in decreeing the suit without there being any measurement and boundary of the area to which easement of necessity was claimed. Heard the learned advocate appearing for the appellant and the learned advocate appearing for the respondent. As could be seen from Schedule B, which is annexed to the plaint, the total extent of land belonging to the present appellant is 3 acres 31 kuntas comprised in two different survey numbers, namely survey number 44 and survey number 45 of Agasavalli village, Taluk, Shimoga. In case of the plaintiff is claiming right of way, the court cannot, the plaintiff has to specifically mention as to which portion, which direction the alleged road is running, and he has to also
Pathway, not road. There is no road in that. It's only a pathway. They have used, yes, pathway. Yes.
He has to also mention as to the extent of that extent of land over which is having easement of path by mentioning its length as well as the width. No such description is found either in the plaint or in any other document. Under the circumstances, it is extremely difficult to execute a decree which is now sought to be challenged by the defendant number 2 in the second appeal. If this decree is allowed to remain, may lead to further complications, as there is no specific, as there is no identity relating to the place where the easement is claimed by the plaintiff. Under the circumstances, this court is of the view that the judgment and decree passed by the trial court as well as the first appellate court are required to be set aside by answering the substantial question of law in the affirmative in favor of the present appellant. However, this is also made clear that the plaintiff is at liberty to file a fresh suit claiming alleged right of easement by specifying the exact location exact location on which he is claiming right of easement in the property of the defendant, if at all such right is existed.
We have one I have no other access to my property. At least till I file the suit and obtain other thing, let there be an order so that let him not prevent me from entering my land.
Oh, madam. No, madam. You can file a suit and you can seek appropriate relief.
No, Your Lordship, it was granted in the trial court. And
The
even
case
if
is,
they
the
have,
case is concluded now. The case is concluded now. You can file the case today itself.
these parties at 2007 and all, they don't come. It is so it's extremely difficult since they didn't have mobile phone also. There is no phone number with us.
No, I really
So,
wonder
at
whether,
least
I really wonder whether the dispute now exists or not. Probably the dispute is not there now.
If Your Lordship, at least
Hopefully the appellant and respondent, who are the brothers, they have buried the dispute by this time.
but purchaser is a different person, Your Lordship. The appellant before Your Lordship is a different person.
All
So
right.
at least for 15 days, let him not. I will see that.
So which place?
That it is in
Over which
Shivamogga.
portion? Over which portion?
No, at least let him one pathway for me to move around to my at least only to a short extent, maybe a small extent.
Over which portion? Nobody knows.
No, there are photographs, Your Lordship, which shows that it is to the edge of his.
No, let them file a suit in case if there is any such apprehension. I have given that liberty. Otherwise, there was no need to mention that also.
Yes, I'm
Made it very specific.
Your Lordship, but at least
No,
this is the one.
I made this observation with the consent of learned counsel appearing for the appellant.
Yes, I
Third day said.
Yes,
I just posed
my colleague told me, Your Lordship.
I posed the question. This suit is being dismissed on technicalities. If really he is having a right of way, what should be done? Then he said, if there is any such right, let them file a suit.
No, that is what.
So he was gracious enough.
Yes,
So he was
even,
gracious enough. Let us assume.
No,
Let us assume
I would ask this thing to at least Your Lordship to at least on 15 days let the status quo remain so that I can at least go to my land. Then
no, madam, it may lead to further complications. The learned advocate for appellants were to be here. I would have made some observations with his consent. He is not here now.
Madam, your name, madam? Your name, madam?
I am Mrs. Jayashree, Your Lordship. Mrs. Jayashree.
Yes. It's really unfortunate, madam, that this case has taken 12 years.
Again, in fact, I have always been ready in this matter. I have not taken thought.
I'm not finding fault with you. It's all collective responsibility.
Yes, I do concede, Your Lordship. But I would have been, if I was able to contact my client, I would have definitely conceded right even before the case was argued. But since I was not able to do it,
yes.
Thank you, Your Lordship.
Whether widow has got a right to file a suit for partition. No, Vinod Sharma has no application in this case.
My only concern in this case is two aspects in this case. It's a divergent time. Number two, the plaintiff filed a case not for partitions, the plaintiff appreciated. He's filed.
No, the counterclaim is allowed now. Now, what is allowed is counterclaim.
All this counterclaim, and also the suit is also agreed.
Okay, what is the suit? What's the she sought a declaration that there is already a partition. Instead of certain properties. One property is kept joint. So she sought a declaration in respect of those properties which she claimed allotted to her in the partition. And in respect of the property kept joint, she sought partition. The court says there is no partition and granted decree in respect of partition in respect of all. Yes.
The defense of the defendants was that Nagappa and his brother parts of blood earlier, as per the general accused. In this case,
Where do you get?
the page 5, the 552.
Page 5.
Straight away, my lord, they start with Bhagavatam.
You dispute the genealogy,
I'm not discussing that.
then
Between the Kavai government and the two sons. But instead of Sarai, this aspect of it. But if I did not, my consent that's topics. There is no woman partition. Here, that is what
your written statement, as argued by the other side, is somewhat in this line. Right now, there is no need for partition. Time is not yet ripe for partition. This was a defense taken way back around 15 years ago.
15 years ago.
Now the contention is the time is right.
My submission would be only these laws. Now the original granting is there. And only at this point we will not have original granting is there. Before this tendency of these schemes. But an application is filed. Appellant Lakshmana died on 9/12/2014.
Original plaintiff.
Original right, 9/12/2014. When an application is filed, under order 22/3. This was 22/3 of 5/3/2015.
That is allowed, right?
The appendice, the copy was not furnished to me. Nevertheless, it is allowed. I filed an application for recalling the order only for this reason. The person claiming as a legal representative is claiming as per adoption date dated T4/2011. That is, evolution of interest is taken place during the pendency of the suit. Proper application would have been in the due course, either 22 Rule 5 or 22 Rule 10. Because devolution has taken place during the pendency of the suit. These are the original.
You dispute the adoption.
I dispute the adoption. That is so, that is clarified also.
In the absence of adoption, the property would devolve upon you people.
No problem.
You are for adoptee? You are for adoptive son? Adopted son.
Only that is clarified option.
It's only for a limited purpose. Adopted son, in the absence of proof relating to adoption, can come on record for limited purpose to prosecute the appeal.
The adoption.
Validity of adoption has to be independently established.
It has to be proved before the validity proceedings. Validity proceedings are always they have to prove their manner.
But to file an independent suit.
First, Lakshmana share has to be decided.
That is decided. Lakshmana, there is no difficulty in quantifying the Lakshmana share. Relationship is admitted or share is. Now, whether you succeed as an adopted son, that is the point to be decided if they dispute the adoption.
Independently file a suit for the.
See, Mr. Now you say that a replication is allowed without serving a copy on you.
After 7 years.
Just a second. So you are aware that somebody has come on record as an adopted son. Wow. You are not questioned.
That's why I filed an application for
Yesterday, my lord.
When?
After delay, my lord, delay, my lord.
So you are aware that application is already allowed.
Should also restore whatever the reason, my lord, application is allowed by the Assembly. But that would not benefit them.
No. What I'm saying is, do not question the adoption. Just don't raise the contention just for the sake of technicality. No, if that lady, I think she was issueless, right? If she has adopted somebody, why do you disturb? Anyway, your share is not taken.
Option, that somebody may force up to something. It is to be accepted.
All right. Did anybody prevent you from questioning the adoption all these years?
Then only this application is filed.
All right. In the application, the assertion is made that so and so is the adopted son.
Then not.
Forget about delay. Now, who prevented you from questioning the adoption?
Only before this one, such an application.
Correct. It is brought to your notice that there is an adoption. Assertion is made. The assertion is made stating that so and so is the heir of so and so on the basis of adoption. You have kept quiet all these years.
Application is not short. However, application is allowed.
On that day,
Virtually, application is 22. After again under 22. If it is under 22,
Just a second. That day the case was listed before this court.
it is true. I would not.
Your name was also not there in the court list.
Not coming again.
No.
Those things will not.
What I'm trying to understand is, your client has not chosen to question the adoption. Your client, I'm not saying you.
It's true. Copy is not served on me. I did not accept. Not again from. Actually, if it is under.
I think the proper course is FTP will continue, assuming that the appeal is going to be allowed. FTP will continue. Parallelly, you have to file a suit to declare that you are the adopted. That is the FTP only for limited purpose.
So, TP may not, virtually may not, already shares are determined. In this case,
Original plaintiff share will develop upon the adopted. If it is established. No, in this case, the court is not going to uphold the adoption. That is for sure. In this case, the court is not going to say anything about the adoption. The court is not going to say that so and so is the adopted son. The application is allowed only for limited purpose of prosecuting this appeal. So remedy is always open to you to challenge the adoption. It is always open to her to file a suit to seek a declaration that she is the adopted son.
Should have been an application of 522 it's a devolution of
Inquiry.
inquiry would have been
So
ordered.
even that inquiry is only for limited purpose.
That's why I'm not saying.
Adoption is registered. Adoption is registered. What was the age? What was the age of the adopted son?
at the time of adoption, 6 years, 6 years.
60. It's written as 60.
At the time of adoption.
Adoption is 2011.
At the time of his adoption, what was his age?
Petitions are made in 2005, my lord. He was registered on 2011.
In 2011, what was his age?
Age 12 years.
In 2011. Yes. In any case, that is within the permissible limit.
That is true. Adoption registration doesn't because the rights of the only for the
Your apprehension is to be taken care of. What will say that appellant has come on record only for a limited purpose of prosecuting the matter. This judgment should not be construed as a binding on validity of the adoption. Separate suit, yes, that's what it says.
Doesn't confer on the right to the property. Should be the settlement of other agreements.
There are two appeals, right? 2 or 3?
Depending number 2 is.
Heard the learned advocate appearing for the appellant in RSA 209 of 2012 and RSA 552 of 2012 and also the learned advocate appearing for the respondents. Common judgment, huh?
Common judgment.
These two appeals are arising from judgment and decree passed in OS number 43 of 2007 on the file of Senior Civil Judge Madhugiri. The suit for partition filed by one Lakshmamma. So, sorry, suit for declaration and partition. Declaration and partition filed by one Lakshmamma is dismissed.
Partly allowed.
It's partly allowed. Which relief is granted? Which relief is granted?
It is not when different defendants are entitled for one quick share in all the scheduled.
Is granted awarding partition in respect of all issued scheduled properties. There was a counterclaim by first defendant, who is also Lakshmamma. In the counterclaim, wife of who is also Lakshmamma, wife of Ramachandra. In the said counterclaim, the first plaintiff gave partition in respect of all the properties. The counterclaim was allowed. Counterclaim was allowed as prayed for. Sorry?
Yeah, it is not, it doesn't say. Profit share, there is no more. 20 defendants are entitled. There's no.
Counterclaim with the yesterday's submission was made.
Counterclaim was there, not considered. However, share is given for all.
There is no reference to counterclaim in the judgment.
In the final order, there is no reference.
In the judgment. Issue is there.
Oh, shoot.
Third issue.
So this may not be.
Is 44 million. Because the defendant number 2 and 4 that the actual properties are accessed that the number.
There may not be a close and so counterclaim. One sentence he might have said that he is also entitled to share. Counterclaim better. It is decreed awarding 1/5 share, alwa? 1/5 share in all the suitable property. This judgment and decree was called in question by Second defendant M.N. Nagaraju by filing appeal in RA number 139 of 10.
Defendant number 2 and 4.
Defendant number 2 and 4, M.N. Nagaraju and Jayamma, RA number 139 of 10. Report, Fast Track Court at Madhugiri. In terms of judgment and decree dated 15 December 2011, the Fast Track Court at Madhugiri allowed the appeal. Allowed the appeal and consequently dismissed the suit. Stop. The appeal was allowed on the premise that Lakshmamma, who filed the suit, being a widow of late M.N. Shivanna, could not have filed a suit for partition during the lifetime of her brothers, her husband's brothers. That is the reason assigned. Stop.
Also, declaration also.
The first appellate court is also of the view that the plaintiff is not in a position to establish a claim relating to the previous partition, and accordingly, the declaration was also not granted by the first appellate court. Agreed by the said judgment and decree of the first appellate court, setting aside the trial court judgment, the plaintiff is in appeal in RSA number 522 of 552 of 2012. Stop. The first defendant is in appeal in RA number 209 of 2012. This appeal was admitted on 6/7/2012 to answer 6/11.
552 admitted at 6/7/2012. Another appeal 209 admitted at 2/8/2012.
That's it. RSA 55 of 2012 was admitted on 2/8/2012 to answer the following substantial question of law. And RSA 2A 55 209 amattandu
going to be admitted on 6/7/2000 Karnataka. It's not any.
ಇದು ಎರಡು 280 ಇದೆಯಲ್ಲ, ಎರಡನ್ನು 280 ಇದೆ. Note ಹಾಕಬಹುದು. RSA so and so was admitted on such and such a date to answer the following substantive of law. RSA so and so was admitted on such and such a date to answer the following substantive. 230 will continue. 230. Where is your senior? Where is your senior? The relationship of the parties is not in dispute. The property was originally owned by Nagappa, son of Ramegoda. He had 4 sons and 1 daughter. The suit is filed by the wife of 4th son, M.N. Shivanna. The first appellate court held that this widow cannot maintain a suit for partition. On that ground, the appeal was allowed and the judgment and decree of the trial court was set aside. This view of the first appellate court is erroneous. The share held by late M.N. Shivanna in the property which belonged to the joint family devolved upon the death of M.N. Shivanna in favor of his wife Lakshmamma. So Lakshmamma could very well maintain a suit for partition after the demise of her husband. The first appellate court erred in not noticing this fact. Under these circumstances, this court is of the view that the judgment and decree passed by the first appellate court is liable to be set aside, and the judgment and decree passed by the trial court is to be restored. In the course of submission, the learned counsel for the respondent would submit that appellant in RSA 552 of 2012, Lakshmamma died during the pendency of this appeal. An application is filed by the person who claimed to be the adopted son of late Lakshmamma. It is submitted that the application is allowed without hearing the present respondent, to whom the copy of the said application was not served. Hence, an application is filed to recall the order passed on that application to bring the adopted son on record. This court has considered the application filed by the respondent to recall the order. Though the application is allowed to bring the adopted son on record, this court has not given any finding on the validity or otherwise of the adoption deed under which the present LR of appellant is claiming right. It is always open to the party to dispute the genuineness of the adoption deed in an appropriate proceeding. This application, permitting the adopted son to come on record, is to be construed for a limited purpose of prosecuting this appeal. Under these circumstances, it is made clear that this court has not given any finding on the status of the person who has come on record as the LR of appellant on the basis of alleged adoption deed dated so and so. The contentions relating to the adoption deed are kept open. Accordingly, the appeal is allowed. Judgment and decree passed by the first appellate court set aside. Judgment and decree dated so and so passed by the trial court is restored. Any of the observations made in the regular order, the IA for recalling the order does not survive for adoption. Then it comes for the respondent to place reliance on 2 judgments of the Supreme Court. Is the objection? The office objection. Date is delay there. Recall model. Date of the order, nodi. 25. Application date. The record, it is apparent that there is delay of March dismissal, alva. October February time. 6 months. There is delay of 6 months in filing the application to recall the order dated 12/3/2012, wherein this court has dismissed the appeal for non-prosecution. In the interest of justice, the office objection raised by the registry on that application to recall the order is overruled. And delay of 6 months in filing the recalling application is condoned. Order dated 12/3/2012 is recalled and the appeal is restored to file. Then appears for the appellant and respondent.
For me.
Welcome. Case was called in the morning session. There was no appearance. During the afternoon session, there is no appearance on behalf of the petitioner. This matter next week as the last chance. You're for respondent. Who wants to come on record?
Middle of the on my uncle to Rashid. He later that to Rashid.
You're for appellant or impleading appellant? Where is appellant? Where is appellant? Suit for? Ah. You filed a suit against whom? Who is here in terms of relation? Strangers, yes. Yes. All right. Now, what is the grievance of your uncle?
My uncle is claiming that 7 acres of land has been honored to be shared, partition. And there is before the assistant commissioner.
So how can you intervene yourself in this case? This is against a third party. If you are having share over the property, you file a suit. Is it, just a second, just a second, just a second. Is it still joint? Or already partition?
Including my land, they will file suit.
Show the partition deed. If it is still joint, your remedy is to file a suit for partition.
Partition ಆಗಿದೆ.
Okay, show the partition. Is filed along with the application. Then without showing your right over the property.
Except that eighth respondent is admitted in the file code.
Forget about 10th respondent. Whether the plaintiff has accepted, you want to join in plaintiff's case.
Plaintiff, who is the plaintiff in the respondent hearing, he is admitted before that.
All right, show the admission, show the admission. Admission before the trial court. In this, you want the court to rely upon that document to allow your application. You want the court to consider that document. A document nodbeka. There is a case pending before this court. You are not a party. Just a second. Allow me to speak for 2 minutes. The case is pending before this court. You are not a party. You want to come on record. You want to be a party to this proceeding. For that, you have to show that you have got some right over the property. So your application to implead yourself should also contain a document on which you want to rely upon. You can't implead it at the request, merely at the request. There should be some basis. The counsel for the impleading applicant seeks time to. The counsel for who has filed IA number 1 of 2022 to implead himself as 11th respondent seeks time to produce certain documents. At his request, Justice Metron. Date. You want to produce document? 20th. Yes. Admission again. I need it. Yes.
For partition. Suit was agreed. The facts.
Filed by whom? Against whom? Where is the genealogy? Heard before this court? Whether I heard the matter? Yes. Rudrana is propositors.
Yes. Son Kalappa brother. The property. He had 3 sons. One Mallappa, Kallappa, and Rudrappa. The plaintiff are sons of Kalesham. Mallappa sons, there are five sons. The Mallappa son, second son, Vannappa not married, died. So Venuvirappa is the 6th plaintiff. Parmeshwarappa, he went into adoption, not in adoption. These plaintiffs are not one of Vallappa's grandmother, Kalesham Maklu.
Yes.
Kalesham. They filed a suit for partition in respect of survey number 22 measuring 9 acres.
So how many plaintiffs joined?
There are 6.
Yes. Yes.
There are all sons of grandsons of Mallappa.
One is son.
One is son.
Yes.
Chandvirappa is
Petition
son.
number 6.
Other 5 are
Yes.
grand.
Now there is no dispute over the fact that
Yes.
property is inherited after the demise of Kallappa.
No dispute.
There is no dispute.
No dispute.
What is the proof? You admit this fact? Your defense is of previous partition.
Yes.
Now just a second. What the trial court held relating to previous partition?
Trial court was decreed. It is the
Trial court.
That family property.
Trial court rejected the theory of previous partition.
No, but see, it is a real 1943. It was a partition. This property was not included. It was still
So,
99. Still 99.
Trial court held the defense relating to previous partition is not proved.
And it is proved.
Defense relating to previous partition.
Well,
That's what I'm asking, madam. Your defense is there is a prior partition in dispute of this property. That is your defense. That is prior partition. So that means your defense is partition has already taken place. This property is allotted to you. This
not included.
That is a defense, sir. So that defense is rejected by the trial court. Yes. First appellate court, they accepted the defense of previous partition.
First appellate court order.
Is it correct? The first appellate court accepted the defense of the defendant that partition has already taken place in the family, and in that partition, the property is allotted to the share of the present respondent.
Partition, they are not given any reason to believe this.
That is understood. The first appellate court accepts your contention that the property is allotted to you. No, it ultimately boils down to this. Genealogy admitted. The property was held by one Kallappa, that is also admitted. So you are setting up a defense of prior partition. Now you have to establish prior partition. Now you have to establish it. Yes, file a suit for partition. Correct. In dispute of this property. So in dispute of this property, you must establish that the partition has taken place, that is allotted to your share. How do you establish it? Or Kirana? Or the burden is on them. Since the relationship is admitted.
Till 91, 92 plot, it was the
Yes.
joint family property.
Good. Correct, Alva? Yes. Understood. Understood. So which year? All right. 1940. 43. All right. Now you have to establish 1943 partition. All right. You show that he had separated from the family in 1943. Show that. All of you could have prepared a small synopsis, should have saved the time of the court. No, you are. Madidira? Then continue. None of us, including the advocates, don't have the luxury of hearing the matter at length now because of the pendency. The synopsis will certainly come to the aid of both the parties as well as the court. So, which paragraph? Huh? 4B. B for Bombay. Yes. Except suit property, yes. Now this partition of 1943, is it evidence in any document? Any mutations? Just 1 second. Suit schedule property measuring 9 acre 21 guntas in survey number 22. This was held by Propositus Kalappa. Right? Now his contention is all properties are partitioned except this property. You say that this property is allotted to your share. Where is the document to show that this is allotted to your share? All right. Now how do you establish that it is allotted to your share? Page number. So one basic question, if it is allotted to your share, why there is no mutation in this regard? 19? Why so late? Why so late? Because the partition has taken place in 1940s. Why for 50 years there was no mutation? All right. In whose name the property was standing from 1940 to 1992? Jointly. RTC. When Kalappa died? So this is agriculture land. No structure built on it. Madam, you are now relying on the oral evidence of the parties to say that this property is allotted to your share. No, let us accept that you are in exclusive possession. What is the consequence of that? They suit for partition. Possession of one co-sharer is possession of another co-sharer. Did you establish ouster? Did you plead ouster? No. Yes. Because you said it is allotted to you. Now establish how it is allotted to you. 220, yes. Yes, I have read. Yes. All right. No. In the next sentence, ದಾವಾ ಸ್ವತ್ತುಗಳು ಪ್ರತಿವಾದಿಗಳು ಮೊದಲಿಂದ ಅನುಭವಿಸಿಕೊಂಡು ಬರುತ್ತಿದ್ದವು ಅಂದರೆ ಅವರ ಸ್ವಾಧೀನತೆ ಅಂದರೆ ಸರಿಯಲ್ಲ. It denies. Your possession is not established here. All right. Now, all right. Let us accept that your possession is established. Possession of one co-sharer is possession of another co-sharer. You admit this proposition, then it is established because the property records. No, you should be grateful to him. He has not claimed partition for 50 years. No, madam, it is like this. All right, no, understand. Understood your point. In 1940, there was a partition. Why it is one property is kept joint, it is not explained by the plaintiff. That is your stand. Partition, yes, that is your stand. Now let us assume that there is no explanation. Does it mean that it is allotted to you? Your possession is not established. He has disputed your suggestion. All right, now let us try to analyze the case from another angle. How much property is allotted to them in 1940? Six acres? 6 acres, and I'm not worried about sorry number. Yes. No, give me the total. I'm poor in mathematics. Roughly. Next month, Mallappa or Sharige.
All the properties have been divided except this property.
Just a second. How many acres have been allotted to you? 15 acres. All right. Tallappa, how much share is allotted to Tallappa? Tallappa and Rudappa stay together or what? Or all three partitions? Yes, how much property? All right, you continue with your yes. Now there is no document relating to 1943 partition. No document, no mutation. Mutation Silva. Why? Now, why that was kept joint? Why anta? So only Mallappa separated in 1943.
Kallappa and Rudrappa.
Mallappa Deshpunti.
Equally divided, right? Equally divided, you know, except.
Distance ಹೇಳ್ತಾ ಇದ್ದೀನಿ, equivalent ಹೇಳ್ತಾ ಇದ್ದೀರಾ, ಅದನ್ನ I am trying to verify.
Except these properties.
How do you say it's equally unless you don't know, unless you know the extent? Unless you know the extent, how do you say it is equally divided? See, at the level of High Court, the answer should be very specific. The court question is whether the properties were equally divided in 1940 or not. You said equally, but you don't know the extent. How do you say? Unless you know the extent of property allotted to the remaining sharer, you can't say, make a statement that it's equally divided.
They have sold the property. Same.
So forget about the sale. What was the share allotted to the parties in 1940? You made a stand that it is made a statement that it's equally divided. What is the basis for you to say so? If you don't know the answer, you can say I have not verified. You can't say equally. If you say equally divided, then you must have the answer. See, I'm trying to analyze this case from this angle. If the property is, let us say 15 acres is allotted to all the sharers, 15, 15, 15. If 9 acres is left out, then it is easy for me to say that it is equally divided among 3 brothers, excluding this 9 acres. That is the logic. If assuming that you have been allotted 15 acres and the contesting dependent is allotted only 8 acres, or sorry, 6 acres, then we can say that 9 acres belongs to them.
They have filed a suit for
This is one angle from which the case is.
Advocate that partition ಆಗಿಲ್ಲ ಅಂತ partition ಆಗಿಲ್ಲ.
Who filed a suit?
The respondent filed.
In respect of this property.
Yes.
That is the best point. Why didn't you? That is the best point. All right. Where is the plane? Where is that plane? That is the best point. You should have urged it in the first instance. Madam, have you filed a suit in respect of the same property?
It is not.
Which page you are reading? So 2 suits are clubbed here. You have withdrawn that suit. So in this plaint, you asserted that this is also joint family property.
Yes, asserted.
No, that is understood. No, that is understood. You also said that this is also a joint family property. So where is that plaint copy? Where is that plaint copy?
Seven of the valid judgment. Ten and 11.
Just a second, just a second. So just a second, just a second. So where is the decree of the trial court? So evidence was recorded in both the cases.
They filed a memo and withdrawal. Earlier, they stand alone. In 1946, there was no partition. Equally, they are entitled to equal share, one third. Later, blood, they withdraw the.
No, are you sure that evidence is not recorded in both the cases?
Yes.
Are you sure?
Yes.
So where is the plain copy in OS number 546? Freedom trial court. So if both the cases are club, it should be here.
The fighter, appeal.
You filed appeal. Which one? Against dismissal of OS 546. Then what happened? Then no second appeal. So the plain copy in that OS 546, they have said that this is also the joint family property. That clinches the issue.
Now, there's been discussion.
Let me see the plain. 546, page number. So there's just one paragraph reference. It doesn't say which are the properties they are.
There are 10 of the trial court judgment. 10 of the trial court judgment. The plaintiff filed a suit against the
Page
defendant.
number, page number.
10 of 10 and 11 trial court judgment. The plaintiff is not responding. But the suit against the defendant for partition and separate position of their 1/3 share.
Correct. I just wanted to know from the decree, what are the properties mentioned in that particular case? Where is the decree? Decree of the trial court.
They have withdrawn. They have withdrawn.
Or appeal ಮಾಡಿದಾರಲ್ಲ sir 546 ವಿರುದ್ಧ.
Technical reason not.
There is a decree ಮಾಡಿಲ್ವಾ? Without decree they filed appeal. See, either the decree or the plain copy. That would clinch the issue, sir. See, they have said that that's a joint family property. That is end of the matter. Their own pleading. They can't go beyond that. I'm asking, where is the plaint?
Discussing the plaintiff. Why is judgment? There are 11 of them.
Whether there is any reference that this survey number is also the subject matter of their suit and
All survey number. All
ಎಲ್ಲಿದೆ ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೇನೆ ನಾನು.
there are 11 of them.
ಎಲ್ಲಿದೆ?
Three facts of the plaintiff.
Take reference to survey number. Don't read entire paragraph.
There was no partition of the suitable property by means and bounds between the place and property.
Which suit schedule property?
All suitable property. All the suitable
In
property.
their suit. In their suit. Madam, did you include this suit in that particular sir?
ಹೌದು, ಇದು
ಎಲ್ಲಿದೆ ಪ್ಲೇಂಟ್ ಹೇಳಿ ಹೇಳ್ತಾ ಇದ್ದಾನೆ. ಎಲ್ಲಿದೆ ಪ್ಲೇಂಟ್ ಅಂತ?
including this property also.
This is simplest possible case. ಇದಕ್ಕೆ ನೀವು ಎಷ್ಟು ತಾಸು ನೋಡ್ತಾ ಇದ್ದೀರಾ? Whether the trial court in its judgment has ever noticed that this subject matter of the present appeal is also the subject matter of OS number 546 of 96 filed by them. Then all ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೀರಾ? All ಅಂದ್ರೆ ನಿಮ್ದು 546 whether subject matter of 546 also includes
11. There was no partition of the scheduled property by weights and boundaries between claimant and defendant.
which suit schedule they are
All the schedule. How is it?
546 ಅಲ್ಲಿ. So 546 ಅಲ್ಲಿ what are the suit schedule properties ಅಂತ ಕೇಳ್ತಾ ಇದ್ದೀನಿ ನಾನು ನಿಮಗೆ, whether ಸರ್ವೆ ನಂಬರ್ 21 is ಹೌದೋ ಅಲ್ಲ ಅಂತ. ಇಲ್ವಾ? 546 ಡಿಗ್ರಿ ಇಲ್ವಾ? You have not produced the plain copy in your suit, their plaint in your suit. The best document. ಇರ್ಬೇಕಲ್ಲ ಹಾಗಾದ್ರೆ ಕ್ಲಬ್ ಆಗಿದ್ದು. You have withdrawn the suit, how can you prepare an appeal? There is no decree. So if common judgment is delivered, then there should be 2 decrees. So where is the second decree in your suit? The trial court judgment alli, sir, the trial court judgment while decreeing your suit, it has observed that in the suit filed by them, this suit property is also included. So there is an admission that it's a joint family property. One sentence is a tursi. This court, after hearing the learned counsel for the appellant and respondent, feels that the plain copy in OS number 546 of 1996 between the same parties. ಯಾವ court ಅದು? On the file of Swiss Judge Kadur between the same parties, and the decree passed therein is are relevant for adjudication of this case. Registry is directed to secure the aforementioned two documents. ನೀವು ಮಾಡಬೇಕಿತ್ತು. Sir, after going through this, now the court has felt that this is required. You could have very well said it long back. Could have produced it. See, if they have filed a suit for partition in respect of the same property where you are claiming partition, it means that it is an admitted fact that the property is a joint family property, there is no partition. Their plaint is a best piece of evidence for you. ಅದನ್ನೇ ತೋರಿಸಿ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದೇನೆ ನಾನು ನಿಮ್ಗೆ. This is not for further hearing on. Telephonic. Date of disposal. Rajan, this is not wrong. 28. For further hearing. 27. See, don't wait for the registry to produce the records. You can also make an attempt. ನಿಮ್ಮ ಹತ್ರ ನೀವು ಕಳಿಸ್ತೀವಿ. It's for appellant, we'll hear it. Yes. Okay. 28th ಅವರು ಆಗಲ್ಲ ಅಂತ. 28th ಮೇಡಮ್. 29th. 29th. ಸಿಟ್ಟಿಂಗ್ ಇದೆ. Yes. Second round.
Second round litigation.
You lost in the first round.
No, my lordship, here, trial court, I am for the defendant. Trial court dismissed the suit. First appellate court reversed the judgment. This honorable court again held in my favor, restored the trial court.
In the first round.
First round. And the
second round was not in your favor.
Plaintiff approached the apex court, wherein my lordship, the apex court remanded the matter with a specific direction to frame an issue with regarding to the adoption, substantial question of.
They are claiming to be adopted, sir?
Yeah, they are claiming adopted.
You are disputing
daughter, adopted daughter.
You are disputing adoption.
Yes, correct.
Who has taken in adoption?
My husband, defendant husband, taken the adoption. That is what her claim. Both the courts here, my lordship, what happened? It appears, my lordship, before the honorable appeals court, we are not properly represented.
No. The question is,
yes, correct.
Who took whom adoption?
My lordship, the adoption, they are claiming that, my lordship, plaintiff claiming she is the adopted daughter of one MC Krishnappa.
MC Krishnappa. So how are you related to Krishnappa?
Lordship, she is a far.
No, how are you related?
I am wife of.
You say that your husband has not taken the adoption.
Both the courts, my lordship.
No, what was the age of the adopted daughter?
My lordship, at the age of 10 years, around 10 years, She not specifically stated.
All right.
My lordship here,
Adoption deed is registered.
no. Both the court, my lordship, trial court and first appellate court consistently held that there is no adoption. Adoption not true. My lordship, properly it is not presented before this apex court, my case, my lordship, because
That's over now.
yes, my lordship, it is reached finality. They have not come before this honorable court and questioned the findings against
No.
about the adoption.
Supreme Court has set aside all the judgments.
No, it
Matter is remitted back to the trial court.
yes, not trial court before to the high court.
Even,
Yes.
what is the question, Prem?
My lordship under
Where is the order of the Supreme Court? Mandate is there. Mandate is there. Mandate. Could you the Supreme Court order?
it is part of the discovery.
So are you party to the adoption deed? You are not.
No adoption deed at all, my lordship.
Adoption deed is not produced.
There is an oral adoption. That's why, my lordship, both the courts are only based on the will. my
How
lordship.
old is the daughter now? How old is the daughter?
Uh,
60.
Okay. Go ahead.
How old is the mother?
Mother, she is 80 years.
Daughter is married.
She's married. She is with the husband.
Settled, well settled.
Because admittedly, her husband is a lecturer. my lordship.
Property belongs to you or your husband.
Krishnappa.
So that is the reason.
The first appellate court held, my
So who
lordship.
is taking care of you?
My lordship, that's what, my lordship. Now, the portion of the property has been sold to the third defendant.
By whom?
Myself, my lordship.
So you are under the care of third dependent. Who is third dependent? Relative?
They are not related.
Not relative.
Here, my lordship, first appellate court only on the ground that will.
Now, what is the observation? Just a second. Read the Supreme Court order. The father has also executed a will in favor of adopted daughter. See, 33/1986, there is a will.
Based on the will, my lordship, the first appellate court said that I don't have absolute right. This honorable court, my lordship, based on.
Who executed a will?
MC Krishna.
In favor of whom?
My lordship, he has given me life estate. Subsequent or after my demise, it has stated that, my lordship, the property should go to writing.
All right. If the life
Here, my
is,
lordship, will,
just a second. Section 14(1) of Hindu Section Act is attracted.
yes,
Then you become absolute owner.
yes.
In that event, even if he is said to be adopted daughter, it's not much of conflict.
My lordship, both the courts now, my lordship, held that she is not an adopted daughter.
Understand the point? Section 14(1) is attracted.
Yes.
Wife becomes the absolute owner under the will.
Yes.
Will is not in dispute.
Yes. Well, will is also
Disputed by you.
yes.
If the court says the will is proved,
Only first appellate court
No.
says that will is.
assuming that this court
Yes,
says
sir.
will is proved.
Yes.
You become,
14(1) attracted, my lordship, absolutely.
14(1) is attracted, you become the absolute
Yeah,
owner.
absolute owner, yes.
Half property have already sold.
Yes.
So that sale becomes valid. Remaining half is the question.
It's not,
See, remaining half, right? You become the owner. Section 14(1) is attracted. You can dispose it of to anyone. So a status as adopted daughter is of little consequence.
as of now, entire property has been sold. One more person has been purchased.
All right.
Another portion also, my lordship, is not in kindly see the judgment. This appeal is directed against the judgment dated 25/3/2009 of the land single judge of Karnataka High Court, whereby he allowed the second appeal filed by the respondents, reverse of the judgment and dictated.
Just a second. It is Supreme Court order.
That is the, I am reading.
No, page number 3.
The land single judge examine the issue of validity of the adoption of the appellant and proceeding to decide the second appeal by framing the following question of law. Whether the vesting of the limited interest in favor of Ramaka first appellant hearing under the bill exhibit P20 has the effect of proceeding the said limited right to the absolute ownership in the hands of the Ramaka view of section 14(1) of the Act. The land single judge held that the right interest are created in favor of respondent number 1 got converted into her absolute ownership under section 14(1) of the Petition Act 1986, and the contrary finding recorded by the lower appellate court is not sustainable. We have heard Mr. T. Vishnu Shetty, land senior counsel appearing for the appellant, and Mr. Sharan Thakur, land counsel appearing for the respondent, and Feroz in the record. In our view, the High Court should have framed the question of law on the legality of the adoption of appellant and Sri M.C. Krishnappa and respondent number 1 and decided the same. If that question was to be answered in negative, then the High Court should have considered whether the appellant could get any right under the bill executed by Sri M.C. Krishnappa and whether the suit filed by her was made. In view of the above, we do not consider any it necessary to examine the correctness or otherwise of the findings recorded by the land judge that by virtue of section 14(1) of Act, respondent number 1 from absolute owner of the property of her husband. In that result, the appeal is allowed, the interim judgment is set aside, the matter is limited to the High Court for fresh disposal of the second appeal filed by the respondent. Observation made in the start. Here my lord, read this that though there is a concurrent finding in respect of
Wife is appellant here. In earlier round, wife is the appellant. Earlier round.
here, my lord. Very same appeal is restored.
Earlier round.
Yes. Very same appeal has been restored. It is decided in 2010, my lord.
Read the 4th paragraph in page number 3 of the Supreme Court order. In our view, the High Court should have framed a question of law on the legality of the adoption of the appellant by C. Krishnappa. Appellant ಅಂತ ಇದೆ ಅಲ್ಲಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ appellant appellant ಸುಪ್ರೀಂ ಕೋರ್ಟ್ appellant ಅದು
No, appellant
ಸುಪ್ರೀಂ ಕೋರ್ಟ್.
yes sir. Adoption of the appellant before the Supreme by Sri M.C. Krishnappa.
That question was answered negative. There is no adoption. Then the High Court should have considered whether the appellant could get any right under the will.
I have considered whether the appellant could get any right under the will executed by the M.C. Krishnappa and whether the suit by her was made.
Now, how do you say that there is no adoption?
Both the courts, my lordship, trial court and first appellate court, concurrently held that, my lordship, there is no adoption. That is not questioned by the.
According to them, what is the date of adoption?
No date. No date.
When you were adopted?
ನಾನು ಒಂದು
trial court.
synopsis ready ಮಾಡ್ಕೊಂಡು
Trial court, what the trial court did?
that is also trial court, my lordship, entirely suit as was dismissed.
Put by her,
Yes, my lordship.
giving declaration that she is adopted.
Yes,
And also she can write under the will.
Yes, my lordship.
Two declarations.
No declaration has been negative.
One is relating to the adoption.
Adoption.
One is relating to the will.
Both are
Will is registered.
registered.
Testing witness examined.
My lordship, one witness has been examined. It has been executed on 30th, my lordship, registered on 4th. He says that, my lordship.
All right, trial court did not accept the bill.
No, it is not.
First appellate court accepted.
Only accepted it. And,
Adoption was not accepted.
as of now, my lordship, since they have not, she has not questioned that finding.
Which finding?
About the adoption, my lordship. She has not questioned before this honorable court. She has not filed any counterclaim.
No, appeal is in her favor.
No.
First appellate court.
RA is in her favor, my lord. She has not questioned the RA finding about the adoption.
Appellate court says the adoption has not taken place.
Only based on the will, it has given the degree.
Yes.
Partly degree.
You are waiting for your senior?
ಹುಷಾರಿಲ್ವಂತೆ ಪಾಪ ಬೆಳಗ್ಗೆನೆ ಕೇಳಿದ್ದಾರೆ.
Senior ಹುಷಾರಿಲ್ವಾ? Heard the learned advocate appearing for the appellant. Admit ಆಗಿಲ್ವಾ?
ಅದು ಅದಕ್ಕೆ ಇನ್ನೊಂದು ಅಡಾಪ್ಷನ್ ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್
ಇಲ್ಲ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಮಾಡಿದ್ದಲ್ಲ.
ಅದೇ ಅದನ್ನ ಇನ್ನೊಂದು ಫ್ರೇಮ್ ಮಾಡ್ಬಿಟ್ಟು ಅಡಿಷನಲ್
Heard the learned advocate appearing for the appellant. This matter was once decided by this court in terms of judgment and decree dated. Twenty-fifth March 2009. The matter was and accordingly alien appeal dismissed ಆಗಿತ್ತಲ್ವಾ? ಅವಾಗ ಹಿಂಗೆ.
Yes, this honorable court allowed my appeal.
This court allowed the appeal and said the order was questioned by the present respondent by filing an appeal before the Supreme Court. The apex court in civil appeal number 9197 of 2010 allowed the civil appeal and remanded the matter to this court with the direction to consider the question relating to the validity of adoption given by the present respondent. Under these circumstances, this court is of the view that the following substantial question of law is to be framed. Munchiನ question ಏನೈತು? In addition to the question of law framed earlier. Stop. Wide order dated. Whether the appellant, whether the respondent is able to establish that she is the adopted daughter of late MC Krishnappa. Paper book beka?
It is already there.
Already there. Is this matter for fine hearing on 2006? Sir, fine hearing. Date. No adjournment on that day. So assuming that you are able to establish adoption, probably be through Sama's case. 1977 Supreme Court 1944, Section 14. You have to get over that. 1977 Supreme Court 1944. Assuming that you are able to establish adoption, assuming that your will is proved, since the life estate is given to the wife, that life estate enlarges into absolute right. Examine that. Further hearing better. Hearing is admission. Admission ಅಂತ ಆಗಿದೆ. Admit ಆಗಿದೆ. Yes.
It is secondary.
Hmm.
For declaration, by the appellate, it will be 15. Even if it's a message by the appellate.
Divergent finding. You are for plaintiff. You are for plaintiff now. What declaration you sought?
That will be so the owner of the extent of the will executed by Trumpa, that's what the property.
The will is not established.
Current practice cannot hold cannot the is true.
The first appellate court.
As request is that the statement and the government will have not been.
All right. Who executed the will?
Trumpa, the father of the grandfather of the
Legatee.
yes, sir.
Propounder. Grandfather.
Devraj is the grandson, Shobha is the granddaughter, and the third plaintiff is the son. Shankarappa is the close relative.
Just a second. Grandfather executed in favor of grandson.
Grandson and grandchildren of all born to his children.
All the grandchildren.
Yes.
Now who is disputing the will now?
The children of
Now who is disputing the will?
the dependents are disputing. Is it correct that there was a registered will?
No, that is understood. Dependents dispute, that is understood. Who are the dependents?
Dependents are the children, the grandchildren, and the son of Grandpa. In case of the son.
Your son is disputing.
There was a bill, registered bill in favor of the children of the patient. That is the sixth dependent people lordship.
Where is the genealogy?
Is the non-existent again.
So when the will was executed?
1991, man.
Date.
$25,990.
25?
1990.
1990. So when he died, testator?
After 3 days, he died on
3 days. Will was registered?
Earlier, bill was registered.
Oh. Earlier will was when it was
But they
executed.
are not by very
No, earlier when it was executed.
13/9/1990.
13/9/1990. It is 9 days earlier to this.
Yes, madam.
That is registered. That is in favor of whom?
Favor of children of the patient, third dependent. That is
All the children.
1 and 2.
All the children.
Only 2 children of sixth dependent. And also in favor of fourth dependent, wife of eighth dependent.
How many children he had? Testator.
Estater had got married the third dependent, sixth dependent.
So why are you not ready with the genealogy?
Just I will narrate well the genealogy. Monday,
The request of
I given stuff available earlier.
the synopsis without genealogy. The first will is not before the court. Whether all the children are beneficiaries under the first will?
Second will, all
First will only.
first will is only the children of the patient are the beneficiaries.
One of the sons.
One of the sons.
How many sons he has?
2 sons, 3 sons.
Testator has 3 sons. How many daughters?
Daughters.
2 daughters. Total five children. So one of the children of one of the sons is the beneficiary of the first will.
First will.
Under the second will,
All the grandchildren are given the equal share.
all grandchildren from all children.
Yes. And the third plaintiff lordship is the center of both dependent, who is the close relative of Rudrappa. He has also the beneficiary.
Signature on the will is admitted or disputed?
Time of the defense, my lad,
that the signature was, the signature of Rudrappa was, grand signature of Rudrappa was available for the purpose of submitting the returns to the income tax. And therefore, by making use of the blank signature and the white
So
paper,
signature is admitted.
signature is certificate. Their case is, my lord,
If the will is not held to be not proved, then instead of grandchildren, children will acquire right over the property. It will go to the same family.
other, since it has equally divided, my lord,
It will be equally divided among the sons now.
ಇನ್ನೊಬ್ರು ಈ ಶಂಕರಪ್ಪ ಅನ್ನೋರ್ಗೊಬ್ರು ಕೊಟ್ಟಿದ್ದಾರೆ ಕ್ಲೋಸ್ ರಿಲೇಟಿವ್ ಇಲ್ಲ
You will allow. You appear for which?
ಫೋರ್ತ್ ಪ್ಲೇಂಟಿಫ್.
You fourth plaintiff gaga. Or you put
we are the I am appealing for the beneficiaries of the second will, all the beneficiaries.
the second will is held to be not proved, or this fourth plaintiff is the loser. What is the extent of land?
There was a partition of the elections of justice needed. House property, site property, and landed property. Totally 3 items are there.
The signature is admitted. You have examined how many attesting witnesses? You examined 3.
The scribe also.
Tribe also. They supported your case. Why the first appellate court says no?
So on both papers, first page and last page, and their signature is not found on the second page.
Attesting witnesses.
Attesting witnesses. And that manner it comes to the
Who is this scribe? Advocate?
No, no, no. Document.
What was the need to change the earlier will?
Since it was given only to the children of Tippeswamy, and moreover, he has been residing in the house of the third plaintiff, Paraswamy, and since he is being looked after by him, that he felt that it was not proper to give the entire property to.
Swami has not claimed the right under the will, under the earlier will.
But his children, right?
These children, under the first will.
First will.
They have filed a case?
Number 1 and 2 are the children of Tippeswamy.
They have filed a case?
They have not filed any case.
Then how do you say that they have claimed?
Yeah, but because they set up their will.
What happened to that
But
will?
they have not claimed any counter claim.
That's what I am saying.
So both wills, the court will has not accepted both the wills.
First will is abandoned.
The second will also both the courts will come to conclusion that it has not been proved. That will also.
So let the property be enjoyed by the children.
I will try.
Why this third party has come into the picture? Distant relative.
Distant relatives and
Why?
he was during his old age he was helping that Rudrappa, and therefore out of his government affection is given the property. Both the property.
Compensate that old relative.
Whatever.
All of you together, give something to him.
ಅವ್ರು ಬರೋದಿಲ್ಲ ನಾನು ಅದೇ ಪ್ರಾಬ್ಲಮ್.
ಯಾರು?
ರೆಸ್ಪಾನ್ಸ್ ಬರೋದಿಲ್ಲ ಏನಾದ್ರು ಸಿಸ್ಟಮಿಕ್ ಮಾಡ್ಕೊಳ್ಳೋಣ ಅಂತ.
You are appearing for
Plaintiffs.
all the plaintiffs, grandchildren and the distant relative who is the beneficiary.
Not all the grandchildren. Rashma is the Tippeswamy son.
You said all the grandchildren are given equal share.
Under the second will.
That's what I am saying.
Yes, sir.
See, under the second will, all the grandchildren plus a distant relative.
Yes.
You pay something to the distant relative.
I can give, depends 1 to 3 can give, whatever the other dependents may like. Rashma Kaindisi may like. The defendants, the children of his son are also given the share in the second will. They have to come forward to give something to the fourth plaintiff. They may not come forward.
So beneficiary is also disputing the will.
According to them, their will is a registered will. And
Grandchildren who are the beneficiaries under the second will.
second will, they are disputing the second will. They are disputing the second will.
Beneficiaries.
Yes.
Grandchildren also disputing second will.
Because according to them, if this will go,
Property would go to their father.
to the dependent 1 and 2 under the first will.
First will is not claimed now.
Though they have not claimed, probably it must be in their mind.
See, when the beneficiaries themselves are disputing the will, where is the case for you? How many grandchildren? How many grandchildren?
Lord. Six, my lord.
6. Out of 6, how many have filed the suit now?
Two grandchildren, Devraj and Shobharaj.
Rest of the 4, they are contesting
They are
the,
not independent.
they are contesting your suit. So they say that will is not executed, though they are beneficiaries. Though it is there against their interest. That evidence, their evidence.
Probably at the time of contesting, probably it is their mind that if this will go, their first will would be upheld. Probably, but in their mind.
So evidence of a person who gives evidence against his own interest, it has got a lot of evidentiary value. So out of 6 beneficiaries, 4 beneficiaries are saying that the will is not executed.
If I can go that.
One day. And one more aspect is within 15 days he died.
Actually, there is a recital in the bill itself that he was suffering from theory and other things at the date of execution.
How old was he when the will was executed?
Thank you.
Anyway, there is no challenge to the finding on the first will.
Both of them have been to.
No, as far as first will is concerned, was there any evidence by the testing witness? So that is abandoned. Monday. The request of learned counsel for the appellant. Mark presents Mark learned senior counsel. RS? Ravi. Sorry, I'm not familiar with the names here.
I know. Problem of my knowledge.
This is not on Monday. Any matter, madam? What is the matter? Sorry? Injunction. What happened? Decreed. Concurrent finding. So pursuant to the decree that deeds are rectified. Bartararu. K. Vijay Kumar. Is he regular? None appears for the appellant. Then an advocate for the respondent is present. This is matter on Tuesday as a last chance. Last chance.
Apologies, Your Lordship.
Citation was taken out.
Sorry? Yes, which matter?
Your Lordship, serial number 39, Your Lordship, serial number 39. I couldn't hear the.
What were you doing? What were you doing?
I couldn't hear. I was under the assumption that it was 38. I was checking the display. I couldn't hear, Your Lordships.
Number 39 or yes, you can comment.
Your Lordship, the suit is for rectification of sale deed and a consequential relief for declaration and injunction as well, Your Lordship. And alternatively, they also sought for possession of the suit scheduled property. For defendant one, the appellant herein is defendant number one before the trial court, and defendant number two has not contested, Your Lordship. Defendant number two, he happens to be the seller of the land to the plaintiff herein.
Seller.
Seller. He sold the land to the plaintiff.
Who are you?
I'm defendant number one. My property is adjacent to plaintiff's property.
Neighbor. All right.
I'm the neighbor. Yes, Your Lordship. The dispute is only with respect to 16 guntas of land, Your Lordship. Initially, Your Lordship,
Now, how this rectification affects you?
Your Lordship.
How this rectification of boundary affects you?
Your Lordship, the rectification, he has sought for rectification, but I am not privy to the contract. The rectification has to be.
All right. You are not privy to the contract. It is between them. How this rectification affects you?
I have lost 16 guntas of land, Your Lordship. I have been in possession of the land since 1962. Since 1962, I have been in possession, and he files a suit in the year 1988.
No decree is granted for possession.
They have alternatively sought for possession. It was given for possession as well, Your Lordship.
Yes.
And even a question with respect to adverse possession was also raised before the court, but the court brushed it aside and
You are not the owner. You are not the owner.
I'm the owner, Your Lordship. I'm the owner, but still, even otherwise, I was in possession of the property from 1962 to until 19.
You are the owner. You are the owner under which title? Under which deed?
Under my deed, it could be seen, Your Lordship, under the deed which was given to me. I'll only take one moment, Your Lordships. On 25/6/1965, I purchased 2 acre 9 guntas of land, Your Lordships, in survey number 116, bar 2B and 116 3B and 116/4 from one Chikka Boregowda, Your Lordship. And in 1968, I purchased 1 acre of land in survey number 116 of 3A from the same person.
The synopsis here? Synopsis?
I don't think there is, Your Lordship. If necessary, I'll file a synopsis.
There is synopsis, yes.
In 1968, I purchased 1 acre of land from in survey number 116 of 3A, 116 bar 3A. From the same vendor, Your Lordship. And the plaintiff herein claims to have purchased about 35 guntas in 116/2A from his vendor.
Third in part. For further argument.
Yes, Your
When do you want?
In any time next week. Yes.
Further argument of the appellant. Madam.
Monday, preferably Monday, Your Lordship. Monday.
Come out with a synopsis.
I will place a detailed synopsis before Your Lordship.
Second. What is that? Publication file? Probate relating to the will. Will is registered. Evidence recorded. Evidence recorded. That's the procedure now. In all the cases, the evidence is being recorded. I have seen in some proceedings, the matter is evidence of the attesting witness is recorded. I think new procedure is adopted. I don't know why. What is that? Last week, 3 days ago, I passed an order. Earlier to that, there was one more case where the evidence was recorded.
The case of a probationer, when the will is because
Formality.
So your lordship will direct it to
Registry will record the evidence. 40.
The only small issue in this case is the witness is a senior citizen and a resident of Chennai, my lord.
VC.
Given an affidavit anyway, but through
UVC. Since probate is a petition is filed seeking probate in respect of bill dated
14th October 2011.
14th October 2011, said to have been executed by late
R. Shiva Subramanian.
R. Shiva Subramanian. Stop. The citation is published pursuant to the order of this court. There is no objection. The learned counsel for the petitioner would submit that how many testing witnesses do there are? One attesting witness is alive and is aged and seeks indulgence of the court to record his evidence through video conference. Request is granted. The CPC, Central Project Coordinator of this court, shall record the evidence of the attesting witness through video conference and submit the and place the record before this. Date
21st. 31st.
So you have to file an affidavit. He has already filed an affidavit.
I filed it with the petition.
His evidence is to be recorded through this.
The same affidavit is what?
Yes, yes. Monday. On 10 matter. So I'm told there are many 2006 and 7 matters. So there is a request from the bar to list all those matters. Those matters will be listed. Yes, first 46 Alva. Which date you want? 46. At the request of learned counsel for learned counsel for appellant and respondent. List this matter on 4th number. 50. 3rd number. At the request of learned counsel for respondent.